location, and I'll show it to you here in a moment. Next to that is another YouTube channel I've made before called Impact Broker Coach, and that has an entire other pre-licensing class in all the various sessions. We used a different book in that class, but it's all the same material, same syllabus, same course. And it's also got math tutorials and some question and answer kind of walkthroughs. Some of the students ran across some practice exam questions they had certain trouble with, and I was able to do either a video, since it's YouTube, I did video responses to those. So that's a place that already has a good bit of material for you. If you keep on coming down here in Notion, the yellow box here is letting you know that the link for the Google Drive is right below it. So that's how you could access the Google Drive. Here is day one. I'll usually put the video and embed it here in Notion as well, or you could go to askneilpinder.com to find it. And then I just put the Zoom link. You'll use the same Zoom link as you did tonight for every class. We don't change that up. And then the policy and procedures handbook there. On the YouTube channel, share that with you. Here's what it looks like. It will obviously get more content as we go because I'll keep adding more things. And then the other one is here. And you can either search it in the YouTube search box or type in the custom domain impactbrokercoach.com. And you can see it's got a bunch of stuff in it. Some of this stuff is just question and answer stuff that I did before. At the very bottom are the oldest videos I made like a year ago, and they have walkthroughs for math problems. All the math problems that you'll be running into in this course, just sort of a narrated walkthrough. So that's hopefully helpful for you. The student access, the student access folder has a few things in it. First of all, the slides Jason used yesterday at the top of the hour are right here. Those are his slide deck slides right there. The license law and commission rules that we talked about. Remember, it's a book if you want to order it for $6.50 from the commission, but inside that book are various sections. This is the 3 major sections you need to use in studying for this course. And there's the comments one and the commission. Yeah, sure. What was that?
Can you go back to how you access that? I wasn't paying attention. I was texting a message over here too.
Let's see. Let's go to.
How'd you get to that?
You can get there through Notion.
Okay.
So if you go to Notion and find the, look, I accidentally zoomed in.
Oh, there it is. Okay.
Yeah, you can just click on that link right there in Notion.
Okay. Thank you.
You're welcome. Oops. All right. And then here we go. So the license law and commission rules, I put them all in a folder, in its own little folder. Click on that folder and you've got the comments section. You've also got the license law and the commission rules as 2 separate additional PDFs. And then if we go back to the main part of the student access folder, we've got the Relink book. I left that in its own little folder, little file. That's got this thing that you should be checking back with from time to time on pages 16 and 17. It's this chart, this one. And you'll want to, especially when it gets to the point of reviewing material, just pay attention to which items have the most testable questions coming from them. So don't forget about that. And then, of course, the process. When it's time to order your background search, there's the information for that. And then the syllabus, your best friend. Hopefully you've printed that out. If not, make sure you do that before next week so that you can write in it, because it's super useful to study alongside. Read that textbook with the syllabus open next to you. And then here's the new thing. I made this last night. It just kind of shows you the breakdown of what we're covering. Not pretty, but I tried to color code it a little bit. So week 1, day 1 was, of course, last night. There's the date for it. And I've put both the syllabus section number and the textbook unit number. Sometimes they're the same thing, but many times they're not. So in this case, for chapter 1, which we didn't even get to last night, we'll get to that tonight. Syllabus section 1 is the same as textbook unit 1, and here's the topics involved. Tonight is day 2, November 3rd. We're going to be covering what we didn't cover last night, plus we're going to go ahead and get into syllabus section 2 and textbook 2 and 3, which is property ownership and interest. This is just a guide. This is not a hard and fast, we're sticking to this to the minute. It's just to give you an idea of what's coming next. Sometimes we might go slower than others. We might go a little faster, might go a little slower, and it's okay. I've kind of got the pacing down, so don't worry if we haven't gotten to stuff. It will all kind of even out in the end, but I just wanted you to have this to see what's coming next so that you could prepare for that. What I've added are these purple sections, and when you see LLCR, that means license, law, and commission rules. And the letters here are the letters within the syllabus. So on the first week, after tonight, probably on Monday we'll review, but tonight we will have covered pretty much sections A, B, and C in the syllabus. What does that mean? Let's look at it. Let me pull up the syllabus. Here we go. Oh, there's a little errant window that I was looking for earlier. We're going to go all the way to section 21 in the syllabus, because that is for license, law, and commission rules. I wish they would put it up in the earlier part of the syllabus, because I think it's important to emphasize to the students that you really need to get this down solid. And that might be part of why the pass rate for the state portion of the exam isn't as good as the national portion. Maybe I should mention that to them. I'm sure they've heard it before. Here it is. So syllabus, section 21 is the license, law, and commission rules. Letter A, which is the super basic stuff. B, which is the composition of the real estate commission. Who's on it? What does it mean to say the real estate commission? The 9 commissioners and the employees that work for them. And then C, general licensing provisions. Remember, section C in the syllabus is everything that you can't get out of the comment section, right? So when you're looking at the comment section here, hopefully you read the first 3 or 4 pages of this. These are about 30 pages in this comment section. This has almost everything. It refers to almost everything you need except for the items in section C from the syllabus. Fortunately, those are like the easiest ones. It's about 10 of them, and we kind of touched on them last night. We're going to go more into them tonight. After this first little bit, which we're going to cover this week, I think I have it on the end of next week. We will dig into this portion, letter D from the syllabus of the license law. My point is to make sure that you have covered this thing in depth by the time we get to it in the course. It would be crazy to wait till the 8th week before it kind of falls in the syllabus, in the course. That would be setting you up for failure, and I'm just not doing that. So we're going to get real familiar with this thing together, and I want you to read the whole thing many times over between now and the final exam. It's that important. And then I've got it split up, and I'll show you the study guide again here in a minute. The next section of it is going to be E and F, which is some general brokerage, and then what does it mean to be a broker in charge? And then the final little bit is G and H from that syllabus section. So I've spread it out. There it is. That is in your class folder available to you. So the purple is license, law, commission rules. This yellow is a reminder that we do not have class on Thanksgiving, of course. We do have class the night before. I wish we didn't, but we do. November 23rd, we do have class, but not the 24th. And then at the end of our time together, I've got this purple as well, because that's where the License Law Commission rules material naturally fits into the course. So by that point, it'll be a big review of it. Just one big review. You guys should be pretty sharp on it by that point, because you've touched on it several times since then, the whole way. The whatever color this is, I think I meant for that to be orange, is just basically review days, and we're going to need them. The more review days, the better. Now, if it takes a little longer for some of this content, because maybe you ask some questions, maybe for whatever reason it just takes a little longer, we've got plenty of days to work with to spill over into if need be. But we're still going to have at least a little over two good sessions for review there at the end. And then your final exam day is January 12th. If for some reason you need to take a makeup because you didn't pass it that time, the makeup is the 18th. So those are in green. So hopefully that helps you. Here's the other thing Jason mentioned, shared contact info. If you want to, you can, oh good, some of you have done that. Feel free to share your contact info, and you can maybe set up some study groups. Don't forget, by the way, you can do a free Zoom account that allows for a 40-minute session. So you could do your own Zoom just like this, and it's going to shut off after 40 minutes, but it's free. So you could do basically this kind of study session together if you wanted to, if somebody wants to take that initiative and set up a Zoom. So that's good. I'm glad you are plugging into that one. What else? Talked about class marker. Okay, good. Now, let's take a look at our slides, do a little bit of a review, and just dig deep into our license law. Pick back up where we left off there. Questions? Let me know if you have any questions. And by the way, don't forget to, if I just keep going and running my mouth, feel free to stop me and remind me that it's break time. I'm pretty good about it, but sometimes not. You won't hurt my feelings. Sorry, 1 second. Looking at the chat here, looks like Rebecca's mentioned something about a study group there in the chat. Good, you guys take a look at that if you haven't already. PowerPoint is going a little crazy on me right now. There we go. Almost there. Okay, here we go. So we left off with some License Law Commission rules stuff. Don't forget the Relink book. Don't forget your various resources, the different publications. Got the syllabus, you got the License Law Commission rules and comments, and the textbook and the Relink. Those are the top four. There are also going to be like a quarter term quiz or test, a midterm exam, and a 3/4 term exam, and that License Law Commission rule exam. And then you've got things available to you to buy outside of the course if you choose to. Other practice exam things. Several of them were mentioned in an orientation email that we sent you. But there's a company called Learn Test Pass, and they have a bank of 1,200 questions, and you can pay to access those questions and take tests that come from those questions for an amount of days. Like I think it's maybe $50 for 90 days, something like that. You can look it up, learntestpass.com. So that's a resource. Dearborn also has something. I think some of you have purchased that already. We included that in that email for you too. If test taking anxiety is a concern, and it probably should be for everybody, because I mean, that's really what it's all about. I wish we could do this differently. I wish we could give out the licenses based on more of a mentorship thing than just a traditional school testing system. But that's just not the way it is. So you have to get past this test. And so the best way to prepare for taking a test is to take tests, right? Once you learn the content, the next phase of your preparation is practicing test taking, right? So do that as much as you possibly can using a lot of these resources. Okay. First thing we learned is who needs a license. Who does need a license? What are some things you need to, what can you do or what can you not do until you have a license? What is it that dictates when you need a license? I'll figure out how to ask the question eventually. When you're doing real estate.
Doing it for something of value.
Yep. For something of value for yourself.
Somebody else.
Yeah, no, not yourself, for somebody else. There it is. Yeah. 3 things. All 3 things have to be in place. Real estate for another person, for compensation, some consideration, something of value. Those 3 things. It doesn't matter who the someone else is. And on the test, they'll probably try to tug at your heartstrings, and you'll be thinking your parents, your mom, your dad, your grandma, your kid. Doesn't matter. That is someone else. And if you do real estate for them and they pay you for it, you need the license for that. You need a license. You need just the one broker license, and that covers all of these things. But the commission also says you still need to get good at these things too. So make sure you have proper guidance, proper training for these things. There are actually 6 different license categories. We are showing 4 of them here because this is about the human element, right? The traditional progression is that you start out as a provisional broker. Once you take your post-licensing classes, within how long? How long do you have to take your post-licensing classes?
180 days.
One more try. Those 3 post-licensing classes, you have a number of months. It's a number of months. It's tricky because it's 18 months and that looks like 180 days. I get that. So be careful about that. We did say something was 180 days last night, and that is how long the background search is for. That's how long that's good for. So these numbers can really get crossed up in your mind. So 18 months is how long you have to take. Just think about it. You've got to take a 30-hour class and do it 3 times, 3 different 30-hour classes. So just think about the logic of that. You're going to need months, right, to take those potentially. Now, if you want to, you could maybe find one school that offers it, but you might need to go to a couple of different schools to pull this off, but you could get all 3 of those done in about 3 to 4 weeks. If you just wanted to knock out all 3 posts immediately, you could do that. And some people do. They just want to get them done. Many firms, like I mentioned last night, require 6 months or less to get this done. But the rule with the commission that you will be tested on is 18 months. And that removes your provisional status. Doesn't mean that you know much more about real estate, right? You've deep dived because of those classes into agency and contracts and closings and a little bit of some other stuff. 303 is just sort of a mix of various topics. 302 is contracts and closings. That's my favorite one, even though it has more math, but it's more of what you're dealing with on the regular basis. But so is 301 because that's about agency, how to be a buyer's agent, a listing agent, and dual agency. and how to interact with clients. And we look at every line of the agency paperwork. We go through a mock scenario together and look at the listing agreement, which is, I think it's about 10 or 12 pages now. The contract is 15 pages, and that's something we'll go through in 302. So you do a lot of the things that a good broker in charge is probably going to do for you or with you in an orientation, right? The first couple of weeks when you join a firm, they're probably going to show you how to fill out a contract, how to fill out an offer to purchase. In post, we go into that again, but with the idea of what the real estate commission wants you to really focus on and learn in light of those things. So that is post licensing, and that gets you rid of that provisional status. Now you're a full broker. You can't be a broker in charge yet until you have 2 years of full-time experience in the business. So if you were on a fast track and you really wanted to just hurry up and get to the point where you could start your own firm, the quickest you could do that would be the 2-year mark. And that's if you could justify and prove that you were a full-time broker doing 40 hours more per week in real estate for 2 years. They really count it up in months, like 24 months. But, and you can break it up. You could do it for like 6 months and then go get a job for 6 months and then come back and do it for another 18 months. And as long as it adds up to the 2 years, that counts. How else do they figure it up? You would need to prove basically that you did real estate full time. It might be a number of transactions. They want to see what you did. How many transactions did you work? But there's not like a magic number required of how many sales you were involved with. Basically, they want to make sure that you didn't just kind of lie about it, that you really did. For instance, if you had a regular full-time job, it's going to be hard for the real estate commission to believe that you worked 40 hours at that job and also worked 40 hours doing full-time real estate. If you're doing it part-time, that could still help you, but you'll need 4 years of part-time real estate experience in order to get to the point where you could become a broker in charge. So if it's part-time hours and you've never done in full-time real estate, it's going to be 4 years they're looking for. Yeah, there you go in the chat. The 3 post-licensing classes are each 30 hours for a total of 90 hours. There you go. Good job. Now, you've got your non-provisional status. You've had that since the first 18 months. You had to get rid of it or less. Now it's been 2 years or more of full-time real estate or 4 years part-time. Now you're qualified to take the class to be a broker in charge if you want to. If you don't want to be a broker in charge, but you want to be able to be one, that's broker in charge eligible, BIC eligible. You do the same thing for both. So whether you want to be a BIC or you just want to be BIC eligible, you still do the same thing, which is take the 12-hour class. That class is not offered by us. We're not allowed to offer it. No school can offer it. The 12-hour broker in charge course is offered by the Real Estate Commission. You take it through them. I think it's cost about $110, and it's 12 hours. And I believe some of it counts toward your CE requirement, but I'd have to double check that. But once you've taken that course, you have an entire year to declare yourself BIC or BIC eligible. So maybe you're not quite ready yet, but you want to get the course out of the way. The course is good for a year. What if something happens like me? I decided to go ahead and leave the previous firm I was with and go ahead and start my own firm. So in April of 2018, I went to the Secretary of State, North Carolina website. I found a name that I liked, did a search to make sure it wasn't used already, and I got a Secretary of State ID number and set up my own LLC. I could have used an attorney to do that. Paid them a little bit more money than I had to pay. I think I did it myself, and it cost about $200. Attorney's probably going to charge you $6,000, $8,000, something like that, but they'll do it better, right? They'll be a little more thorough. They'll give you more of the things that you need. You don't have to do it yourself so much. So I did that, and then I contacted the Real Estate Commission online, and I said, okay, I've got my LLC set up. I want to turn it into a firm. So please create a firm license for me. I need to register this firm and get a firm license number. At that point, I had to start paying $45 to renew the Neil Pender license that I've had for, at that point, I think 21 years. And then another $45 every year I pay to renew the firm license. Why is that? Because I no longer do real estate in the name of Neil Pender anymore. I set up the LLC so I could do real estate in the name of the LLC. What's the point of an LLC or any sort of an entity like that? LLP, S Corp, C Corp. What's the point of even setting up an entity? Tell me in the chat or speak out if you want to.
Protects your assets.
There's some tax advantages. There's some liability protection. Not a bad idea, right? There's various reasons to do it. And so I set that up and I got the firm license. Well, a firm has to have a broker in charge. I think somebody made that comment last night, but it flipped by in the chat and I lost track of it. But yes, every firm, every office, in fact, has to have a broker in charge to oversee the brokers within it. So since I set up my own firm, even though it's just me, and I had no intention even back then of hiring anybody right away, I have to have my own BIC. And I could have hired somebody to be a BIC for me, or I could just be the BIC myself. And so I chose to be the BIC. So I declared myself broker in charge. I had not yet taken the course, the 12-hour course, and that's okay. If you declare yourself to be a broker in charge, then you have to take the course within 120 days. So if you go ahead and declare yourself broker in charge, like I did, the commission says, well, we're not going to give you an entire year to take this course because you need to hurry up and learn about being a BIC. So you need to complete that course sooner than a year. So those are the two timelines around the broker in charge class. If you take the class first, before you declare yourself BIC or BIC eligible, then you have an entire year to declare yourself. Okay? But if you go ahead and declare yourself broker in charge because you've created a firm or you went to a firm, they hired you to be the BIC, you have 120 days from that point to get it done. So you need to know those two time frames there about the broker in charge class. Once you have it, the only thing you have to do to keep it is take a special version of the continuing education update course. You don't even have to pay extra money. There's no extra renewal fee for the broker in charge status. When you take a CE class, the continuing education class, do you remember how many classes we have to take for continuing education every year? How many? It's
3.
For post licensing, it's 3, but for CE, it's 2. Yeah, 2 for the total 8 hours. There's 2 4-hour classes for a total of 8 hours every year. 2 4-hour classes you have to take for your continuing education requirement. One of them is a general update, which is pretty much the commission saying, here is exactly what we want you to teach them in the general update. Because we've had some trouble with certain disciplinary activities. People seem to be kind of bad at material, or maybe they get a lot of cases of negligent misrepresentation in the previous year, and they want to put a section about that in the upcoming course to make sure everybody's up to speed. It's kind of driven by their disciplinary action they've been dealing with. What are agents bad at recently? Last year, we had a section on assistance animals and service animals and the laws surrounding those and what are the requirements and what can you do and not do. You can't just say, hey, what's wrong with you? Why do you have that dog? That would be illegal. There's only certain ways you can address that and talk about that. And there was also a section on racial equity in light of a lot of the protests that had been going on. This year, the big main section is about material facts because, gosh, I think they showed the breakdown chart, and I believe it's like 55% of the disciplinary action that the Real Estate Commission has been dealing with in the past year or so has been about material facts being handled incorrectly. We're not telling people that something is wrong, in other words, and we're required to. Exactly. Perfect, Matthew. Matthew summed it up there in the chat. After you take the broker in charge course, there's just the one course, the 1 12-hour broker in charge course, then you have as much as a whole year to declare yourself broker in charge or BIC eligible. If you go ahead and declare yourself first, then it has to get done within 120 days. That's good to see it written out that way. Okay, so CE is 2 courses. I'll show a graphic for you in a minute. It's 2 4-hour courses, a general update, and then the other course is a 4-hour elective of your choice, whatever you want. There's all kinds of electives. There's things about ethics. There's electives. You know, sometimes it has to do with other hot button issues. When I got in the business in 1996, synthetic stucco was a big problem that was being done improperly. Water was getting in there and people were having houses rotting from the inside out. So there were elective courses about mold and synthetic stucco, and could be a material fact one. It could be a property management one. There's also commercial real estate elective courses. If you want to get a taste for commercial, find an elective, satisfy your 4-hour elective credit while learning about something you want to learn, right? And then sometimes you can take some things that you have to take, like when you become a realtor, you join the trade association that's called the Realtor Association. You have to take an ethics course every 2 years as part of that requirement. You can either take one for free through the Realtor Association. That's just an online, hit the play button and watch it, and it takes you 2 or 3 hours. Or you could take a longer one that also satisfies your elective credit, and you can knock both of them out at the same time. So some things count for elective credits for you. By the way, you can stockpile 1 extra elective class per year. So here in your first year, when you get your license, when you're trying to learn all that you can, might not be a bad idea to just take an extra elective if you want to get good at something. Maybe something about investment real estate or how to. Basically, all electives have to be something to do with how it helps the consumer. There won't be ever any electives that are all about just the agent benefiting only, like how to make $1 million in real estate or how to run a social media ad. It's got to all come back to, does it help the consumer in some way? But you could carry an extra elective credit over from 1 year to the next. You can just do one like that. You can just carry one over. You couldn't just have nothing else to do and take 10 electives and never have to take another elective for 10 years. Couldn't pull that off. So that general update, if you are a broker in charge or BIC eligible, you will not take the general update. Instead, you would take the broker in charge update. And here's the secret, not really a secret. It's pretty much the same class. It's all the same stuff except about 20 minutes of broker in charge related stuff. The Realtor Association, so you'll pay a prorated amount of dues depending on the time of year that you join it. I'm looking at a chat question. How many classes and how often do you have to take classes if you join the association? The only thing that's required of you for education to be a realtor is the initial orientation that teaches you about the code of ethics that we agree to follow, and then the ethics training every 2 years. It's due like December 31st of every second year thereafter. So another question was, you guys can't see it. It was, once this class is completed, you can obtain a real estate license. To become a broker, you must complete the post class. So the terminology is this. Once you complete this class and take the final exam, you will be authorized and given the go-ahead to take the PSI exam, right? So you'll apply with the Real Estate Commission, and they'll say, okay, now you can take the PSI exam, go set it up. And you'll set that up. You'll take that and pass it. And so when you pass the PSI exam, you become a provisional inactive licensee, a broker, a provisional broker with an inactive license. When you first get the license, it is inactive because what you need to do to make it active is pick a firm or pick a BIC to affiliate with. Once you've picked that firm, that broker in charge is going to fill out an online form at the commission website and say, she's with me now. She is one of us. She's affiliating with us. So now activate her license. For the record, she is now with ABC Realty. But you're called a broker from day one. And then you're just needing to, from that point of getting your license, because you passed the PSI, you've got to complete those 3 post classes within the 18 months. And then you'll get rid of the provisional status. Then you'll be a full broker or a non-provisional broker or just a broker. You might see it referred to as any of those three things. For the test, for the class test and the PSI, they might just use the word broker by itself. And when they do that, they're not talking about a provisional broker. They're talking about somebody that has gotten past the post-licensing classes and is a non-provisional broker. So be careful. Don't accidentally think in your mind that they're talking about a provisional. If they're talking about a provisional broker in the test question, they will say those words. But if they don't have the word provisional in front of it, then it's not a provisional broker, it's a full broker. So be careful. Okay, yep, that provisional status is temporary. Here's what the three classes look like. 90 total hours, 3 30-hour courses. Any order, doesn't matter if you take 301 first or not. Just 18 months to get them done or sooner. If you don't take your CE by the deadline of it, or you don't take your post-licensing by its deadline of 18 months, you become inactive. And as a provisional broker, you can't do as much as you can when you're not provisional. You have to pretty much keep your broker in charge apprised of what you're doing. They have to know what's going on with all of your transactions to make sure you don't harm the general public or harm a consumer, to make sure that you're learning the ropes and doing it correctly. So you got to be closely supervised by your broker in charge, which is probably why most brokers in charge want you to get rid of your provisional status sooner than later, because, that just puts them kind of on the line. They're also being looked at real hard by the Real Estate Commission. Once you get rid of your provisional status, you're just a plain old broker, a non-provisional broker. You've completed the classes. Now you can act independently. In other words, your BIC is kind of letting you loose a little bit. They're not checking in on you unless you need them to, but they're not worried about you because you know more. You've taken the classes. You are now also accountable for your own screw-ups. If you mess up, you're going to the Real Estate Commission hearing by yourself. Your broker in charge is not required to go with you unless they blatantly do something wrong. But if they didn't know what you did, it's not on them to be in touch with you as closely as back when you were a provisional broker. Broker in charge. This person that is over the whole office full of brokers, supervising the provisionals really closely, but they also have some supervisory roles or duties for the advertising. So, how many of you have seen a real estate ad on your social media from a friend or a realtor? We all know realtors, right? Even, I bet every one of you knows more than one. So how many of you have seen one of those ads? Sometimes those ads aren't done properly. They could be what's called a blind ad. And that's a testable item. What is a blind ad? We basically, when we run an ad, what do you think would be the best way to make a potential buyer call you about a house for sale? They would probably call you more easily if they didn't think you were an agent, but they thought you were the seller, right? So if you were allowed to, if it was all about just getting the phone to ring, the smart move would be to not admit that you're a broker in your ad. But that's not okay. It's not allowed. That's what's called a blind ad. It's when you don't admit that you're a broker. So in an advertisement that you're running in your role as a broker, you have to tell them, Neil Pender, broker, XYZ Realty, and my phone number. Now, got to admit that you're a broker. Got to put that in every advertising. When you're a provisional broker, and for me, this is the biggest reason for me to go ahead and get rid of that provisional status. Because if you're a provisional broker, you definitely have to put your name and the fact that you're a broker with your firm, but you also have to include the general phone number for your firm, not just your cell number. You can include your cell number too, but you have to put the firm's phone number. What happens when somebody calls the firm main phone number? You're not probably answering that phone. And what a lot of firms will do is rotate who is on call duty. And sometimes that phone will be directed to your phone because you're on call time. Or it might be directed to the person in the next cubicle from you, down the hall from you. There's probably several brokers in your firm that are willing to take potential leads that come in when the phone rings. What if you're not on duty that day and you run an ad and somebody calls on your ad, but they choose to dial the general firm number? And maybe even it's your listing that you're advertising. Somebody called on your listing and they didn't talk to you because they called the general firm number. And so they got that guy down the hall because he was on duty. Okay, I'm all for being a team player, but if I can help it, I want that call coming to me. So let's hurry up and get rid of our provisional status so that we don't have to put the general firm phone number in our advertising. But that's a blind ad too. As a provisional broker, it would be a blind ad if you did not include the general firm phone number along with all the other information, right? So that broker in charge is in charge of making sure that everybody's running ads properly. And that's one of the things they're looking for. Did you run a blind ad, or did you include all the pertinent required information? Another way that agents screw up advertising is with fair housing violations. Sometimes not even intentionally because there's some sort of prejudice bigot or something, but they forget and maybe they're trying so hard to describe the property and its benefits that they'll make a mistake and they'll say a word like this. They'll type a sentence like this: adorable bungalow just down the street from the Jewish Community Center. When we get to chapter or unit 19 about fair housing violations, we'll learn that would be illegal. That'd be a violation. We can't refer to religion. That implies that you only want buyers that are of the Jewish religion, the Jewish faith. It could be interpreted that way. And when it comes to fair housing categories, it's not your intention that matters. It's how it was perceived by the offended party that matters more. It's held to a high standard. We have to get this right. Also, if you're fined surrounding a fair housing violation, the fine is tripled because it's a fair housing related issue. We'll get more into it when we hit that chapter. But that's the other thing your broker in charge is looking for, to make sure you didn't violate any fair housing laws when you wrote your advertising language, because it's easy to do. But the good rule of thumb to help you stay clear of that sort of thing is to describe the property, not the people that might want the property. Talk about its features and benefits in and of itself as a property, not like who might want to live there. That keeps most people out of trouble. So we talked about due diligence money last night and some ridiculously high amounts. So when a buyer makes an offer on a property, they have to, well, they don't have to because it's not required. It doesn't affect whether it's considered a contract or not if there's no due diligence money. It's just that, will the seller even consider the offer if you're not giving them any due diligence? Right now, probably not. Good luck buying a house without due diligence money. Most sellers would probably say, nope, I'll take the one that came in right before yours that did give me some due diligence money. The other check you have to write as a buyer, again, it's negotiable. You don't have to, but just depends on what kind of market it is and how much of a seller's market it might be, is called earnest money. Who's heard of earnest money? That's been around a long time. That's basically good faith money. With earnest money, you're showing and proving by setting aside your own money that you're serious. You're saying, look, I can really buy this, and I'll try to convince you that I can really buy this by giving up some of my money, putting it out of my own reach. It's still my money, but I'm going to let the firm hold it, or I'm going to let the closing attorney hold it, and I don't have access to it for a certain amount of time. Once we get to the closing table, it will be counted as a credit to the buyer's side. It's that much less money the buyer needs to bring to closing. But it's just showing, hey, I'm so serious about buying your house that I will set aside this money out of my own reach. That's earnest money. The due diligence money is a whole different animal. In fact, it's called a due diligence fee because fees are not refundable generally, right? Pet fee. When you rent something, the pet fee, you're not getting that back. That's for the privilege of having that pet. The deposit, the security deposit when you're renting, that's something you might get back because it's a deposit. So think of it that way. Earnest money deposit could be refunded to you. The due diligence fee, almost never going to be coming back to the buyer for there's pretty much no reason unless the seller just completely breaches their end of the contract. We'll get more into that later. But there's rare instances where the buyer's ever going to be able to expect to get the due diligence money or fee back. So, since the due diligence fee is non-refundable, it goes straight to the seller directly. Nobody holds that in the meantime. When you get a property under contract, the buyer writes the check for the due diligence money to the name of the seller, and it gets sent over to the seller immediately. And that seller can spend it immediately. Just like you can spend a pet fee immediately. It's never coming back to the buyer. It's yours. Now, it will be credited to the buyer at closing, but it is spendable and given directly to the seller right away as soon as the property goes under contract. The earnest money is different. Remember, the earnest money is still the buyer's money. It's just being held by someone else. How do you hold earnest money for someone else? You can't, as the firm, the broker in charge, cannot put that earnest money check and deposit it into the firm operating account, right? The same account where they're paying the light bill and whatever else they do. That's their own money. It's got to be a special account in addition, separate from that operating account, and it's called a trust account. And there are rules that you have to know to get through this class, to get through the test about how to handle trust money, the trust account money. So earnest money goes where? Not to the seller, but to the trust account. Who holds the trust account? Who has it? It depends. A firm does not have to have a trust account. Let me say that again, write this one down. A firm is not required to have a trust account. What happens if I write an offer? I don't have a trust account, by the way. I don't have to. I don't want to mess with it because I would have to reconcile it every month, and it'd just be another thing to have to do. So if I write an offer, I would tell the other agent at the other firm that has the listing, you're going to have to hold the earnest money because I don't hold any earnest money. I don't have a trust account to hold it in. And they might say, okay, that's fine. No big deal. Or they might say, well, we don't have a trust account either because we've chosen not to do that ourselves. If neither firm has one, you just pick a closing attorney a little sooner and let the closing attorney hold it because most attorneys have trust accounts, right? Somebody's got an account called a trust account where this money is going to sit during the under contract period. If the firm does have a trust account, the responsibility for it lies with the BIC. So that's what the yellow words are talking about. The BIC is over the advertising for everybody in the firm, and the BIC is over the trust account if there is one. Now, does the BIC have to look at that every day and write the checks and deposits and reconcile it? No, they could delegate. They could hand that duty over to like an office administrator, but they are still responsible for it. They would need to make sure that that person's doing it right. Some amount of frequency, they need to check in and see, are they still okay on this, still doing this correctly? And by the way, if your firm does have a trust account and you're the one in charge of it, you're the broker in charge, you have to take a trust account course through the Real Estate Commission, just like the broker in charge course is through the Real Estate Commission. So they offer that as well. Schools don't, it's through the Real Estate Commission. So you know what the rules are about how to take care of someone else's money. We talked about the orange point here, active full-time license for 2 years to become BIC or BIC eligible, or 4 years part-time. And then we talked about that course already. Now, let's recap. We covered, where'd they go? These 4 things: provisional broker, non-provisional, broker in charge, and BIC eligible. There's another thing. There's another kind of broker license. It's a weird one. It's not a very common one. There's only 250 of them. Remember, there's like 126,000 licenses in the state of North Carolina. Some of them are inactive licenses. 82,000 of them are active licenses. 16,000, you don't have to know all these, 16,000 of them are firm licenses, but about 250 of them are this thing: a limited non-resident commercial broker's license. What the heck are we talking about? It's commercial real estate only. There's no such thing as a limited non-resident residential broker's license. It's only about commercial. Think about this. A company wants to expand into North Carolina. Is that company gonna go hire a North Carolina broker? Because maybe they're also expanding into 3 or 4 other states. They're not gonna have a broker for every state. This lets them send their resident, their staff real estate person to the state of North Carolina. And as long as that real estate person for that company is actively licensed in the state that they come from, they can come here to North Carolina and do real estate without a North Carolina real estate license under these conditions. It's got to be for commercial purposes only, not residential. They can't be a resident of North Carolina. They have to be a resident of wherever they're coming from. And it's limited in scope to the situation at hand. They're coming here for the expansion or whatever it is that they're doing for this sort of a one-off kind of a situation. So they're an out-of-state licensee handling a commercial transaction in North Carolina. But you might be thinking, yes, sorry, thank you. Good time for a break here. Give me 2 more minutes. You might be thinking, well, if they're not from North Carolina, if they don't have to have a North Carolina license, how are they going to know the rules and laws? That's the second bullet point. They have to have basically a sponsor. It's called a brokerage cooperation agreement with a North Carolina firm who will keep them in line, who will supervise their activities and make sure that they do real estate properly and follow the North Carolina rules and laws. So that's it. That's the gist of this thing called a limited non-resident commercial broker. It's for commercial. They can't be a resident of North Carolina. They're coming here to do a limited kind of scope of duties for their company. They're out of state and they have to have a brokerage cooperation agreement with a local North Carolina firm. And that's the person who is supervising their actions, but is also handling the trust money if there is any. If there's some earnest money that needs to be put in a trust account, they have a local broker who is looking over everything and they would use their trust account. When we come back from break, we'll talk about firm licenses. So let's come back in 10 minutes. Welcome back. So glad to see you. Had a couple things in the chat. Just a little note here, just to recap about the ads. You can see there, to be properly run and for it not to be a blind ad, it needs your firm name, the firm phone number if you're a provisional broker, and the fact that you're a broker. If you're non-provisional, all that same stuff, except you don't need to include the firm name. Okay. Now, if you set up a firm, that firm is going to be doing real estate for someone else for a fee, right? Just like you were. This time you're running it through the name of your firm. Therefore, it needs a license too. Obviously, your firm can't sit through a class, can't sit through a CE class, so it gets its education qualifications through you, the one who started it, right? But that firm needs its own license. So that's what I did. Started an entity, created an entity with the Secretary of State, told the Real Estate Commission about it, and they issued me a firm license for my firm. Whether you're setting up an entity that's called an LLC, Limited Liability Company, or an LLP, Limited Liability Partnership, or a C Corporation or an S Corporation, it could be any of those things. It's your choice between you and your CPA as to which one you should do in setting up your entity. Then you set up an entity, you have to have a firm license. The entity has to have a license. And now you've got 2 licenses to be responsible for. 2 sets of $45. You do not need to take extra CE. The CE that you take for yourself, those 8 hours, those 2 4-hour classes, that's enough. The firm license does not require extra CE education or anything like that. Just more money. What can that firm do? The same stuff we do, right? List and sell property. You're just doing it in the name of the firm. When I have a closing, I go to the closing at the attorney's office. It's officially called a settlement meeting. We sit there. Hopefully it's boring. Hopefully it's anticlimactic. You don't want drama on closing day. Hopefully you've gone to great lengths and it's all worked out, so everybody's just kind of hanging out and doing their thing. The drama is no fun, but it happens. People sign what they're supposed to sign. And a couple of hours after that, the attorney has got the go-ahead from the buyer's lender, if they're using financing, that the loan is funded and that everything checks out. Then the attorney is going to take the deed to the courthouse, either physically or electronically, probably electronically these days. But they're still waiting in line, by the way. Just because they're recording the deed, the word recording something, when you record something, that means you're putting it out there for the public record, for anybody in the world to have access to it. The deeds to properties are public record. It is not until that deed has been recorded at the courthouse and put on the public record that the closing is officially done. And it's not until that point that everybody gets their money. You don't get your paycheck until it's closed. The seller doesn't get their proceeds until it's closed. And most of the time, the buyer may not get their keys until it's closed. It's up to the seller if they're willing to do that or not. Closed means recorded. We'll get into great detail with that when we hit chapters 9 and 10 and 21. So, we're listing and selling property in the name of the firm. When I have a closing, that attorney is going to give me my check, and because I have a firm, they're going to write the check not to Neil Pender, but to Impact Carolinas Realty, the name of my firm. I'm going to take that check, deposit it into the account, and then I take my part from there. Or if I worked for like Keller Williams or ABC Realty, I would get the check from the attorney in the name of my firm, and it's not my firm, right? It's not the firm I own in that situation. I just work for them. And I take that check back to the office, turn it in with all the paperwork, and the firm office administrator cuts me my check to my name, right? So that's kind of the process. That's kind of how that works. So listing and selling and representing buyers and sellers both, and if you're handling rentals, leases through your firm, auctions. If you have an entity and a firm license, and through that firm you're doing auctions, or even just making referral fees, all the same stuff that you need a license for as a human, the firm can do the same thing. Real estate for someone else for compensation. Now, this is the stuff that you need a license for. These are things that someone that does not have a license can do in this business. Why does this matter to you? Well, when you inevitably succeed in this business, right? Guaranteed, just kidding, hopefully, and you get so busy that you can't do like the basic stuff anymore, you need to be spending your time. Your most valuable dollars per hour activity is meeting new people and helping them buy and sell real estate or whatever it is you're doing in this business. Not making flyers, not delivering lock boxes or signs, not running Facebook ads, not doing any sort of basic admin stuff. Now, we do need to do that in the beginning because we have no choice. But as soon as you're able to afford it, go sell another house and let somebody else do the $10, $15, $20 an hour work of these other things on this list can take up your entire day, all day, every day. But they don't make you any money. You have to do them as part of the process or see that they get done. So you might hire an unlicensed assistant. Somebody that does not have a license is okay, and it's allowed for them to do these things. They can put data or listings in the multiple listing service. They can open up that website, plug in the 1,578 square feet, 3-bedroom, 2 baths, brick, whatever. You don't really need to be spending your time doing that. While they're taking it could take an hour to put a listing in the MLS or more, because you got to post. I think we can put up to 45 or 50 photos in there these days. It can take a while. What can you do with that hour or two? All kinds of stuff that actually could turn into business, more business. So putting MLS info in, obtaining things, going to pick up documents, running things across town. By the way, in this modern age of email, it's not all that modern, but we still use it, texting, electronic documentation, DocuSign, .loop, the things that we use for electronic signing. If it gets right down to the wire and we're in the week of closing, the last week, and some document needs to be in the hands of the lender and it's a local lender, that is my number one activity, to make sure that document gets to that lender. Because if it's holding up a closing, which means it's holding up the seller getting their money and the buyer getting their keys and me getting my check, there's nothing more important for me to do than that thing, whatever it is. Even if it's buying a refrigerator for somebody that's mad and they're not going to go through with the deal unless they get a refrigerator. All kinds of crazy stuff happens. So, point is, for the most part, running a piece of paper across town in the general non-pressure situation, don't do it. Let somebody else do it. But if it needs to get done and you're the only one available to do it, the job description in this business is get it closed. There is no job description past that. I've been on roofs. I've vacuumed floors. I've replaced blinds. I've done all manner of things because maybe there wasn't enough time to hire somebody to do it, and the seller's mad and the buyer's mad, and we're just trying to get it closed, and let's just get this thing done so we can close and people shut up and sign papers, right? To me, that's the job description. Some people have a different attitude about that. They're like, well, that's beneath me. That check's not beneath you. So do what it takes to get that check. First and foremost, do what it takes to get your client squared away. Because by getting your client squared away, you will eventually get your piece of it. So that's the job description, guys. Putting boxes on, signs, providing basic information to people who call. If somebody calls in and says, tell me about your listing at 123 ABC Street, and you're the broker, you can tell them all about it. And if they say something like, well, would they take less than asking price? You could talk to them about that too with your seller's permission. If they call in and you don't answer the phone, but your unlicensed assistant answers the phone, they can't talk about negotiating type stuff. They couldn't say whether or not your seller would take a lower price. but they could just give the basics off of the information sheet. They could say, oh, let me read it here. 3 bedrooms. What else you want to know? Square feet? Oh, 1578. And, oh, where is it? Oh, the city of Charlotte, whatever. They can read the basics. But if the person says, well, gosh, 350 seems kind of a lot, would they take 320? Let me let you speak to my broker boss. I don't have a license. I'm not qualified to go there, right? The unlicensed person can provide basic information, but that's it. They can coordinate appointments, schedule things. They can prepare pre-printed forms for their broker boss, for licensees. A licensee is someone with a license. This is someone that does not have a license. What can they do? They can fill in the blanks, but there's a condition there. We're going to look at all of the contract, the standard contract, the various agency paperwork that hires us, and I'll show you those forms that have blanks that we're authorized to fill in. If we're filling in those blanks to show it to a client, then that's the task of a broker. A broker would do that. But an unlicensed person can fill in the blanks if the reason they're filling them in is to give them to you, their boss. You're the broker boss. They're filling it in so that's to save you time. They're going to fill in the blanks upon your direction, hand it to you. Then you're going to present it to your client and say, okay, look, this is what this means, and this is this, and sign right here. They would not fill out that pre-printed form and show it to the client themselves because they don't have a license. They can't handle the questions that might come up about what means what. But they can fill out that pre-printed form for you to then present to the client and handle the questions from. So that's what that means. Okay, we're going to talk a lot about the sales side of the business, contracts, closings, but there's also rental involved in our industry. And you might get into a phase of this business that's all you do is property management. Anybody doing it or have done property management or is interested in it? Got one, got a couple. Okay. So that's its own animal in and of itself. It's a little different. When you have an assistant who does not have a license and what you're doing is sales, then this is what they can do. But when you're a broker and you're a property manager, and let's say you hire an unlicensed person and they're working for you as a salaried person, a W-2 salaried employee, salaried as opposed to a commission. We as brokers work for commission, 100% commission. If we don't sell, we don't eat, right? When you're a W-2 employee, which I'm sure many of you are or have been at some point, you're making a salary, right? You're making a check every couple of weeks. They pull out FICA and whatever else, and you kind of have maybe some confidence that that's your job and it's okay, and you got this dependable amount of money coming in no matter what. When you are a property manager and you have unlicensed people working for you, because they're W-2 salaried employees working for a property manager in the rental side of this business, they can do a little more without a real estate license. They can do a little more activities that might otherwise require a real estate license. One of those things is showing the rental properties. They could actually show rental property without a license. On the sales side, that's a no-no. That is an absolute no way. An unlicensed person cannot show homes for sale, properties for sale. Why? Why is it rental? You can show a rental as an unlicensed, but not a sale property as an unlicensed? Because the conversation is more likely to go to the negotiation side of things, probably on the sales side. That's the best I can figure. When it's a rental that you're showing, there's very little negotiating happening. Most of the time, a renter is looking at a rental and they're like, how much is the rent? Oh, $2,200. Okay. They're not usually saying, would you take $1,800? A little more likely that they're going to maybe start talking about would you, could you, right? Negotiating stuff when it's a sale property. Therefore, unlicensed people cannot show homes or properties for sale. Write that down. That is a testable question. Can't show properties for sale without a license. You can show properties for rent without a license, long as it's for your employer You're working for your broker boss and it's a property they're in charge of managing. Then you can show that rental property without a license. And this last bullet point is different from the 2 points ago. And that is, you can execute a pre-printed lease for your employer when it comes to renting, like a lease. So execute, that means dealing with the tenant themselves and signing on behalf of your employer. That's okay for rentals. That's not okay for sales. You would never execute a sales contract in a sale on behalf of your, an unlicensed person can't do that. For that matter, a broker wouldn't do that either. A broker wouldn't sign a contract or an offer for their client. That would not be okay. We can advise them, we can guide them, but we don't sign for them. So executing a pre-printed lease for an employer is allowed for an unlicensed person to do. Okay, let's talk about the commission. The commission, when you hear the word real estate commission, that's a lot of meanings. Some of you might think money, and that's not wrong. You're going to sell real estate to make a commission on the sale. What we're talking about are the people who run the show, the ones who make sure we follow the rules and laws properly. So even that, though, is like two different groups. One group is the actual commissioners. It's a board of 9 real estate commissioners. I showed you their pictures yesterday. And those 9 real estate commissioners are the ones who meet every month. They meet for 2 days every month. And they talk about the business of our North Carolina real estate industry. They're going to talk about education requirements. A couple years ago, when the whole illness which shall not be named happened, and we had to kind of do some things differently and figure out how to do the things this way. Zoom, what are the Zoom requirements for real estate education? The real estate commission piped in and said, here's how I think we should do this. Here's how we're saying this has to be done. The disciplinary action, I showed you that the first moment I met you. I flipped right to that disciplinary section and said, look, here's what it looks like when they do it wrong and they get in trouble for it. The real estate commissioners at their monthly meeting say, oh, who did what? Oh, this person did this thing. What are we going to do about it? What did they say? They're going to look at the data. They're going to look at the evidence and the information from both sides and make a determination. There are 4 different possible disciplines they could do. We'll get into that later, but it's reprimand, censure, suspension, or revocation. They could revoke the license. That's for the Board of Commissioners to decide. So who are these 9 people? Who makes up the Real Estate Commission Board? There's 9 of them, and they serve 3-year terms. These are testable items here. It will never be all fresh 9 people, 9 brand new people at once. There's overlapping terms, obviously. Who picks them? It's not a voted in thing. They're not getting voted on next week with everything else. They are appointed. The real estate commissioners are not voted in. They are appointed by who? 7 of them are appointed by whoever the governor is at the time. If one of those terms, or one of those 3-year terms expires and now they need to fill that new space, and it's one of them that needs to be appointed by the governor, then the governor in office at the time, right now Roy Cooper, would need to appoint a replacement real estate commissioner. So 7 of the 9 are appointed by the governor. 1 is appointed by the North Carolina Speaker of the House, and then 1 more is by the North Carolina Senate President Pro Tem. Okay, it's a board of people running the real estate industry of North Carolina. Clearly, we need some real estate people on the board. So at least 3 of those 9 have to be licensed brokers. But in the interest of checks and balances, making sure that we don't just kind of put our interest as the real estate people in the whole state ahead of the general consumer, at least 2 cannot be in real estate. Side note, not a testable item, but what I've noticed, the ones who are not realtors or not brokers tend to be attorneys. by the way. Just a little observation I've made. So just know these things on this slide. 9 total, all appointed, never voted in. 3-year terms, 7 by the governor, 1 by the Senate, 1 by the House. 3 that are licensed brokers, and 2, at least 2, that are not in real estate at all. Certainly it could be 5 or 6 that are licensed brokers. It could even be 7 that are licensed brokers, as long as 2 of them are not in real estate. And it could be as many as 6 that are not in real estate, because a bare bones minimum, at least 3 have to have a license, right? I would venture to guess that it tends to be about 4 and 5, a split of around 4 one, 5 the other, but that doesn't matter. What do? Well, they clearly have to do with the licensing process. They issue licenses to brokers and firms. They also are in charge of registering timeshare projects. Anybody ever sat through a timeshare sales pitch? Every time. Was it in North Carolina or maybe South Carolina or Virginia or Florida or maybe Nevada? I get the feeling the other states might not have the real estate commission in charge of their timeshare projects, and that's why maybe it's so kind of hardcore salesy. I don't know how they are in North Carolina, but the real estate commission registers the timeshare projects. They kind of make those timeshare developers answer to the real estate commission. They've got to provide certain disclosures in order to do it right, to make sure everybody's on the same page and understands what is involved with that timeshare. The commission also establishes the education requirements. They're the ones that say it's a minimum of 75 hours for pre-licensing, and the 30 hours for post, and the 4 hours for CE. It's their fault. Blame them. They're also the ones that determine the dates that those things are due for both prospective and current licensees, and then investigating the complaints and then protecting the public. That's their overarching goal. Their overarching purpose is not to protect us as brokers. The goal of the real estate commission is to make sure the consumer, the general public, is protected against us, from us. So, what if once you're a broker, maybe you have some sort of dispute with another broker. Maybe that other broker worked with a client of yours and they claim that they should get the commission, and you think you should get the commission on that same person who bought something. Who would they complain to if they're mad about it? Would they call the real estate commission? Who's being hurt? Is it the consumer or the 2 brokers? Not the consumer, is it? So the real estate commission is like, well, I'm sorry you 2 brokers have a dispute about who should get the money, but leave us out of it. We don't want to hear it. Is the consumer harmed? Then talk to us. Then we care. But if it's a broker to broker dispute, don't even call the real estate commission. They're not going to handle it. They're not in that business of you having a tiff with another broker. Who you would pursue that with would be the local realtor board. Are you both realtors? Then talk to the realtor board, and they'll do maybe like an arbitration hearing, and hear the side, both of your sides, and decide who should get what. You would complain to the local board about a dispute with another broker, another firm. But unless, what could you do though to the real estate commission? Might you contact the real estate commission when it comes to another firm or another broker? Not a commission dispute, but what else could it be?
Is it if like they violate something?
You got it. Good job. So let's see here. Let me show you just how easy that is. You just plug in ncrec.gov. Oops, didn't like that. There's the Real Estate Commission website, homepage. You scroll on down, hit that button, and start filling in the blanks. Hit submit. Maybe upload some files, some pertinent information if needed. It's going to get to an employee at the real estate commission. They're going to review it. They're going to say, first of all, is this even an offense? My second year in the business, I was, I think, 23 or 24 years old, fresh out of licensing school within the last year. So I knew, like you guys will know, all the laws and rules that there were at the time. I knew because I had to, because that's what it took. 3 years earlier, my childhood home, across the street, the little boy that I used to play with growing up, he was 4 years younger than me. In high school, he ended up accidentally killing himself, accidentally hung himself in the basement. Watched the news with his mom. He's a big kid. Went down to the basement to his little man cave and did what you probably have guessed he did, and hung himself accidentally. Didn't have a way to save and get himself released from the pressure around his neck. His mom found him 30 minutes later, and he died. He had died. So they managed to stay there for 3 years, just kind of, living with the memory, the ghosts, and they did the best they could. His dad was what I call a professional Boy Scout. He worked for the Boy Scouts of America, and this was in like the mid-90s. So he was very in tune with kids. He had a heart for kids, and he wanted to make sure no other kid did this. And so he wrote an article for the newspaper and put that out kind of publicly. Hey, this is a thing. Look out for this thing. Don't let your kid do this thing. 3 years later, here I am back home, had graduated college, came home, got the real estate license. It was one of my first listings. My neighbor across the street from my childhood home was this little couple. They had tried their best to keep living there. They managed to do it for 3 years. Finally, they're like, we just can't do this anymore. We didn't ever talk about it, though. I never addressed it. I knew why they were selling, clearly, because I knew what happened. But we never even brought it up or mentioned it. I just went in there as sort of a real estate guy and said, okay, you want to sell it? Here's what it's probably going to sell for. Here's what I'll do to get it sold. And we did. And we sold it to a guy who was engaged. This guy, single guy, but engaged guy, his real estate agent was the mom of his fiance. And as Murphy's Law would have it, the move-in day after closing, one of her girlfriends, for some reason, knew that this house had this horrible thing happen in it 3 years earlier. She said, is this the house where that boy hung himself? And understandably, in retrospect, looking back, I totally get it. She freaked out. The fiance who was planning to live there with her fiance boyfriend, her mom was the buyer agent. She couldn't see herself being there. And I understand that. But in the moment, back then, as a brand new agent, I was so focused on my seller, getting rid of the bad memories and moving on. It never even really occurred to me that anybody would care. It wasn't like there was crime scene tape or any sort of evidence or something that you would know. But what you haven't learned yet about material facts that we'll probably get to tonight is that the fact that someone has died in a property is not a material fact. If somebody dies in a house, you do not have to tell anybody. It is not considered a required material fact. If the roof leaks and I, as a broker, know the roof leaks, I have to disclose that. That is a material fact. But death in the property or suicide in the property is not. Now, if they came to me and asked if it happened, I could either say, I'm not going to answer that question, or I could say what I do know, and I'd have to answer it truthfully. I could not say, no, nobody has died here, because that would be a lie. I could say, basically, I plead the fifth, I refuse to answer, which kind of is an answer in and of itself. Well, the law, fortunately for me, was on my side. Foolishly, naively, I didn't even think about it being something someone would care about. I was so focused on my client getting out from under this horrible memory that it just didn't even occur to me. But the moment, 3 days after closing, when that agent, who was an agent in the business for 10 years, by the way, at that point, she called me hot. She was mama bear mad because it was her daughter who was going to be living there. And the daughter was upset about it. She said, "Why didn't you disclose this material fact to me?" I was fresh out of licensing school. What I did know was the laws and the rules. First, I was mortified because it dawned on me in that moment, oh my gosh, that poor girl. I felt terrible that she was freaked out by this, and I totally understood in the moment. But up until then, it never really occurred to me. I was stupid. I will admit that. But I also was able to say to her very kindly and cautiously, I'm sorry. I hate that this happened. I didn't mean to, wasn't my intention to kind of try to trick anybody. But it's not a material fact. I wasn't required to disclose it either, and nobody ever asked. A 10-year agent. She should have known better. She called it a material fact, and it wasn't. So, first of all, a couple lessons here. Number one, you're brand new. You coming out of this class and passing this, you'll be a brand newly licensed. You're going to know the laws and rules better than most agents will, except for us teachers. But most other agents, 10, 15 years in the business, you're going to probably be sharper than they are about that stuff. They get kind of slack over time. You just kind of get into a sort of a groove or maybe a rut, right? So what it didn't dawn on me back then as a 2-year agent when all this happened, it took like 20 years. And I was randomly thinking about it one day, and I realized, you know what? I'll bet I wasn't the only phone call that agent made that day. She called to rip me a new one, understandably, but I'll bet she also tried to turn me into the real estate commission, understandably. And when she probably did that, she called him and said, this agent didn't tell me this material fact that somebody died in this thing, blah, blah, blah. And that person that she called, maybe it was their attorney, somebody in their attorney department or their complaint department or however they do it, said, well, ma'am, I'm sorry, but you don't have a complaint that we can pursue because he didn't do anything wrong. Right? So, good question. If the buyer's agent asked before the sale if anybody had died in the house, in our CE class last year, because I teach the CE classes too, they actually cover this, and they said, the real estate commission said, if they ask you, you can't lie about it, but you don't have to tell it either. If they ask you, your choices as the agent who knows for sure that it happened are two. You could either say, I refuse to answer that question, or yes, someone did die here, but you can't say no one died here. That would be a lie. You can't lie about it, but you could choose to not answer it. Not that that would necessarily help anything. They'd probably get even more upset or frustrated if you refuse to even answer it. What all of this boils back around to is talk to your seller about it. Let's figure out what the seller wants to do, right? Because everything leads off of the seller's wishes. Now, you're responsible, as we'll learn in chapter 7 and 8, to carry out the seller's directives and wishes, but not just anything they say, only the lawful directives that they ask you to do. So you would have to explain to them how the ins and outs of this thing works and figure out, okay, how do you want me to handle this? Do you want to just disclose it right off the bat? No, just want to wait and not disclose it. If they ask, then how do you want to handle that? So you would just address it, figure it out, lead by what the seller wants, as long as it's within the bounds of the law. Good question. If they're in the contract already and then they find out and they're mad or upset and they want to not buy the house, a seller can choose not to buy the house for any reason or no reason, period. You cannot force a seller to buy a property. The question is, how much money will the seller be? I'm sorry, a buyer. Did I say seller? I meant buyer. You cannot force a buyer to buy the property. The question is, how much money is that buyer going to be walking away from? How much money will they lose if they don't buy the property? They don't have to buy it, but which of those checks are they going to be losing? Remember the two checks, due diligence and earnest money? It depends on where in the phase of the under contract period that they decide not to buy it. we're getting a little ahead of ourselves, but within that under contract period, the time it goes under contract, everybody has signed and it becomes a contract all the way through closing. During that time, there's an amount of time within it called a due diligence period. It involves a deadline date, 5 p.m. on the fill in the blank date that everybody negotiates and agrees upon. It might end up being about 3 or 4 weeks. Maybe the closing is in 5 weeks. The due diligence date might be at about the 3 or 4 week mark. During that due diligence period, the buyer can do any kind of inspections, have a survey, have the appraisal, make sure the financing is going to go through. Because if they back out before that due diligence deadline day, then they should get their earnest money back. The earnest money they put in, as long as they back out within the due diligence period, they should get that back. I'll explain why I said should later. Let's not get into that yet. But they're definitely not getting their due diligence money back. That's gone. It was gone day one of it going under contract. It went straight to the seller immediately. What if the due diligence deadline comes and goes, and now we're after that date? We're after 5 p.m. on that date because it's literally time is of the essence. The due diligence deadline period expires at 5 p.m. on the date that we put in the blank. So at 5:03 p.m., we're outside of the due diligence period. If at that point or any time thereafter, the buyer chooses to walk away, then they've lost the due diligence money already, but now they're also going to lose the earnest money. Right? So they can back out whenever. They could back out the morning of closing, but they're going to lose that earnest money. They already lost the due diligence money. They're losing the earnest money too. It would be an awkward situation. It would be ugly. People would be mad. And then you'd have to remember, oh, this isn't what I saw on HGTV. This part is no fun at all. I hope this never happens again. Hopefully none of it is your fault. Hopefully you communicated properly and nobody can blame you for any sort of miscommunication. But it's all about that deadline. A buyer can back out, by the way, for any reason or even no reason. It's just all about the money that they're walking away from. So that's how easy it is to report somebody to the real estate commission. And you better believe, I'm sure you would not be surprised, and I wouldn't either if I had real numbers in front of me, that they get a lot of complaints that don't turn into actually being valid complaints that need to be actually pursued. Fire up this PowerPoint one more time. Okay, good. Oop, gotta fix that. Not figured out how to make that not do something weird. Okay, there we go. Okay, so what can they do to us? What are the 4 main ways the Real Estate Commission disciplines us? These 4 things on the left. They can either reprimand or censure us. Basically, those both are sort of a slap on the wrist. Note in the file, hey, you screwed this up, don't do it again. Not serious enough to have a suspension or to revoke your license and take it from you forever, but you didn't do it perfect either. We're reprimanding you. I've sat through an educator's course before because we have to take some courses every year. And somebody asked, what's the difference between reprimand and censure? And someone from the Real Estate Commission said, we don't really know. But if you get in trouble the first time, it's probably going to be a reprimand. If it's another second time, maybe about something similar, maybe they'd bump it up to a censure. Just know these 4 words: reprimand, censure, suspension, and revocation. If you remember, we looked in that disciplinary action and we saw at least one that was a suspension. But what they'll also do is make it a conditional suspension sometimes. They'll say, you are suspended for 24 months. And you would think, well, that means they can't do real estate for 24 months. But they might say, we're going to suspend that suspension, which means, yeah, you're suspended, but you can still do real estate. We're just going to make your suspension conditional on you completing some courses. Maybe it was an ethics related complaint that you screwed up. You didn't disclose something properly. You need to take a class to learn how to do that right again. Clearly it didn't stick the first time. So as long as you take the class, then you can keep doing real estate. But if you don't take the class by the time they require you to, whatever it may be, then your 24-month or however long suspension will kick in. So it could be a conditional suspension kind of a thing. And then revoke means buy. Go somewhere else, do something else, go sell insurance or cars, but just don't sell real estate. You're disinvited from the club, right? And on the right here is a VIP, very testable question. The one thing that the Real Estate Commission does not do to licensees to discipline us is charge us money, to fine us. They do not fine us. They will not fine licensees. Who could fine us? The MLS might fine us if we put a listing in wrong, or the Realtor Association could fine us if we break some kind of rule or ethics thing from them, but we'll never be fined by the commission themselves. They're going to do one of these 4 things on the left, not fine us though. However, like any good rule, there is an exception. There is one kind of licensee that could be fined. And that one is a timeshare developer. Remember, the commission oversees timeshare projects. Well, a timeshare developer needs to have a real estate license. They could be fined $500 for every violation of the Timeshare Project Act, the Timeshare Development Act. If the Real Estate Commission wants to discipline a timeshare developer, they could do any of these 4 things and or fine them as well. But no other type of licensee, anybody that's not a timeshare developer, would never be fined by the Real Estate Commission. And again, just to reiterate, the Real Estate Commission would not become involved between a dispute between agents about a commission, about money, or civil suits, just violations related to licensing law. What do you need to have in order to get your license? Well, you got to be 18 or older. Had an 18-year-old in the last class I taught. Got to have a social security number, be a U.S. citizen or a qualified alien, or have a work permit. Got to pass this class we're in right now, which means pass the final exam for this class. And you have to pass that PSI exam, which has both a national and a state portion, and then submit the background report and the character study, the character check. That's it. That's what you need. It's a pretty low bar. Yes, this course is challenging, but for the most part, I mean, gosh, try to start a McDonald's or a Chick-fil-A franchise. I mean, that's a lot of money to buy a franchise or any other franchise, right? Relatively low financial barrier of entry. If you can get through the education piece, it's about as cheap of an industry you can get into with the amount of upside there is. I don't want to paint too rosy of a picture because it will be hard work. Make no mistake, you're going to have to work hard. You're going to have to be tough and have a thick skin and be able to deal with the word no and just shake it off, laugh it off. But, and all the sales tricks, every no leads to a yes, blah, blah, blah. All that stuff is true. It's all big mindset thing to be successful in this business, to even be able to keep getting up in the morning and dealing with it sometimes. But once it starts clicking, and once you kind of develop some trust and have a core group of people that really love and trust you and go to you for their real estate needs, guys, you can do quite well. Quite well. I'm not going to say quickly because it might take a while to get to that point. But just like any industry, the one who works the hardest wins, right? You kind of make your own luck in the form of being ready, being good, and letting people know that you're available and being willing to work hard at it, right? You know, it all depends. How long do you think it will take to kind of get there? It just totally depends on your own situation, and it's not fair. There is no fairness in this business in terms of, no, we don't all start from the same place. Some of us are introverts. I am a self-confessed introvert by nature. After this class, this 4 hours of talking to you guys, I love this. I enjoy it. But I'm going to need a minute. I don't want to just jump back into talking to a bunch of people for 4 more hours. I'm going to need an hour of just decompression time. And back when I taught in person, for sometimes classes will be all day, 8 hours. Definitely. Some people are extroverts like my brother. They feed off of it. They would turn right around and go out to like a bar and grill and hang out with their buddies immediately because that's how they recharge. I recharge with quiet. But it still works. I used to think you can't be an introvert and succeed in this business, but there are other introverts that would rather work with people like them. They don't want that type A personality always in their face, just always got something going on. They might want somebody more laid back. There's room for everybody, right? So it depends on your sphere of influence, how good you are at loving on them, making sure that they know you're available without sounding too pushy either. There's a myriad ways, tons of ways to do this business. None of them, some of them are better than others, but there's no one way. So I can't answer how long is it going to take because it depends on what you have in your corner, right? You know, knowing who died in the house, I don't know really. As a broker, I would probably, just to keep things simple, I wouldn't even ask, but if the seller told me, then I would deal with it. But no, I don't know, besides maybe some sort of Google search, but I don't think that would be completely 100% dependable. So no, I don't know of any like database that talks about people who've died in houses. Okay. Here's the education. We've talked about it, but here you can actually see it, which kind of helps. That whole visual side. On the left is the new folks, both people who don't have licenses yet, you guys, pre-licensees, as well as what you'll be once you get your license. You'll be a provisional licensee. What you need are these things. You need a pre-licensing course. Welcome. You're here. 75 hours minimum. You also, at that point, once you get your license, need to take the post-licensing requirements, the 3 30-hour classes within 18 months. That's all for the new up to 18 months or less folks. On the right is everybody, including the new folks. All licensees have to complete continuing education. 8 total hours, 2 4-hour classes every year. Now, here's some good news for you. Let's say everything just goes perfectly for you. What was our last day? I think January 12th, maybe the 18th. So all of that goes perfectly. You end up getting into the PSI and taking that, let's say maybe in February. Maybe you get your license March 1st. You could get your license as soon as February or March if it all goes perfectly. The deadline for continuing education every year, do you remember? I said it yesterday, but it was real quick. Anybody remember what the deadline for CE is? It's in June. Yeah, there it is, Gregor. June 10th. June 10th is the deadline for the 2 4-hour, total of 8-hour CE courses, June 10th. So if you get your license March 1st, March, April, May, that's about 3 months and 10 days before the deadline for CE. Well, what's the point of you taking CE? You just got out of a 75-hour pre-licensing course where you learned literally all the rules and laws. So the Real Estate Commission says you get to skip your first June 10th deadline for CE. If you pass this class, get your license, let's say by February or March, you don't have to take CE by this coming June 10th. I don't like to say you get to skip the first year because it may not be an entire year's worth of time that you're skipping, right? What if in March, you're only getting out of like the first June 10th, you're going to have to take it by June 10th of 2024, right? That will be when you have to take your first CE is a year and 3 months later, right? But you don't have to take it by this June 10th. What if maybe you decide to just, for some reason, you pass the class exam, but you don't take the PSI until July. And then it all goes well and you pass it. Let's say July 30th, you get a license. When is your first June 10th after getting your license? it'll be June 10th of 2024. You can go almost an entire year before needing to take your first CE, right? So it's your first June 10th. Just think of it that way. As a new licensee, you can skip your first CE deadline after getting your license. So don't confuse these two things. It's two broad categories of education. Post licensing is 3 30-hour classes. It's temporary. You can't just take forever to do it. Continuing ed is forever. It's every year. That's due by June 10th. It's for everybody. I have to do CE. I teach CE. By teaching it, that satisfies my requirement to take it because I've gone through the course. I've just taught it. But for everyone else, they have to sit through it and take it. Here's the testable thing. The post-licensing courses, you're going to have taken 90 hours, but none of those 90 hours will count toward any of your continuing education requirements. They don't cross over. And nothing you take for continuing education can count toward your post-licensing requirement. They are separate. You can't substitute them. So just remember that. Good time for a break. Let's come back in 10. back. We're at the halfway point. Congratulations. Deadlines, just to hit that point home one more time, because this is easily confused. When is continuing education due? CE is due by when? June 10th. There it is. That's the 2 4-hour classes. One is a update, one is an elective. Your choice. Total of 8 hours, due June 10th. What happens on June 11th if you wake up and you realize you forgot the June 10th deadline? Is your license inactive on June 11th? Be careful, because it is still active. From June 11th through June 30th, you're still good. If you could talk everybody who you're expected to close with in July, if you could talk them into bumping it up sooner, you'd be okay. But from June 11th through June 30th, you're still active. You just know for a fact that on July 1st, your license will go inactive. No way around that. There's no last minute CE available to take between the 11th and the 30th. Not available. Can't take one. There is none. They won't let us give any. You better believe we could probably charge triple if we were to be that kind of person and offer a CE between 11th and the 30th, but the commission won't allow us to even offer them. So everybody taking CE probably in July is sort of, let's just say, under duress, a little bit stressed. Not very many people who are not recently inactive are even bothering to take CE in July, even though you could. By the way, we were up the number of actively licensed in both provisional and non-provisional was 84,000 in May. But when the July thing rolled over, it went down to like 78,000. So a lot of people went inactive. It's climbed back up to about 82,000. So a lot of people fixed it and got back okay as well. So the post-licensing deadline is not a hard date. It is 18 months from when you got your license. It's not like a certain date every year. And then the money is due. The $45 to renew your license is due on June 30th. Don't mix that up with CE. Just like your power bill. That's due the day before the deadline, right? So June 30th is the day before July 1st. What is special about July 1st? That's the start of the licensing year. Therefore, you can pay your money all the way up until June 30th. You do that online, by the way. And no, you cannot set up a direct pay option to just pay those dues every year. The commission won't let you, because it's more than just paying the $45. If you could, all of us would do it, because it's a pain to remember to do it. But the commission wants more from you than just the $45. When they have you renew that license for $45, they make you answer a couple of questions every year. Hey, are you doing certain things properly? Just to have you kind of on record as, well, we asked you if you were doing this right, and you said you were. So there are a couple of questions you have to answer. So I doubt they will ever make it super convenient and auto pay possible. Just have to do it. Okay, a reminder, provisional broker has to be best friends with their BIC in terms of the business. That BIC has to know what's going on. They can't act independently. They got to be supervised by the BIC. And the BIC is accountable for the actions of that provisional. Good question in the chat. Does the post or CE courses, do they require you to pass tests? The post classes do, the CE classes do not. So for your every year, for the life of being a broker, CE classes, it's all about bottoms in seats. It's all about being there for the required amount of time. If you were to try to leave early, you do have a small window you can miss, but not much. But you can't miss the last 20 minutes of the actual class. That's not allowed, or else everybody would leave early. But that's just a time spent in the room kind of thing. For post, it's a mixture of time in the room as well as a final exam. But those final exams at the ends of all three of those posts are kind of not the same level of intensity as your pre-exam will be. The post exam is more, it's a little more relaxed. It's probably, you've covered it, all that information. It's only a 30-hour course, and different schools offer it in different splits. We see lots of different splits. Some schools will do like all day, 8 hours or 7 hours, 2 days in a row for 2 weeks in a row. Some schools will do some sort of a weekend split. Some schools will do like this, like a 4-hour nighttime situation. So you have to shop around and see what fits your schedule. You could also do a post-licensing class without an instructor live in your face. It could be a self-directed post-licensing class, but they all have a final exam. But they do tend to be a little easier. Prohibited acts. We're going to talk about some prohibited acts here in a moment. And when it comes to prohibited acts, from time to time, you'll see these little battery symbols. That means level 3. You might see 2 bars instead of 3. That's level 2, and 1 bar, obviously level 1. So we're going to be talking about some level 3 material here in just a moment. Here's what we touched on a moment ago. The fact that somebody died in a property is not a material fact, but there are lots of other things that are material facts. And we as brokers have a duty to everybody to discover and disclose. Discover and disclose. Write it down. Brokers have a duty to discover and disclose material facts. Who do you owe that information to? If you know it about a property, you owe it to everybody, not just your client, the whole world. If you know that 123 ABC Street has a leaky roof, and you meet somebody in the grocery store and they say, "Hey, I saw your sign in the yard of that 123 ABC Street. What can you tell me about it?" That's not your client. That's just some stranger you saw in the grocery store. They recognize you because they saw maybe your picture on the sign. But you would owe them the information that the roof leaks. You've got to tell everybody. Now, you're probably not just going to be shouting it as you walk down the road. Forgive this wrapper as I get this cough drop. But you would need to put it out there in the multiple listing service, right? Kind of put it out there in the publications, in the advertising, maybe the notes, the remarks section about the property. You can't hide it. Good question. If there's a pedophile next door, that is true. That is not a material fact. There are 3 things that are not material facts. 3 categories that fall under the term stigmatized properties. The death or suicide in the property, that's a stigmatized property, not a material fact that you have to disclose. If it's haunted, anybody ever been in a legit haunted house? You ever feel like you've been in a haunted environment? Any ghost activity? My wife wants to go to Savannah and go on some of those haunted tours. But that is not a material fact. I did actually just learn from another instructor that in Hawaii, ghosts are a material fact, and their property is worth more if it has ghosts. So when she told me that, my first thought was, well, that means a lot of people are lying about ghosts in Hawaii, right? I mean, really? Probably. But in North Carolina, ghosts are not a material fact. And then the third one is sex offenders. The sex offender registry. Anybody ever gone to that website, sex offender registry website? You can just type it in, Google North Carolina sex offender registry, and it's got pictures. You can see these people. You can see the little write-up of the age of the offender and the age of the victim, which will creep you out. But they don't really categorize it much beyond that. In other words, sometimes the offender is 18 and the victim was 17. And sometimes that's a terrible thing because the person did something disgusting. But sometimes it might be because they just decided to date and maybe the parents didn't like it and maybe somebody decided to exercise their ability because you dated a minor kind of thing. So definitely creepy if it's a 60-year-old and a 15-year-old. Maybe not the same thing if it's an 18 and a 17. There's no differentiation there. You don't get all these details. So therefore, Why is sex offender registry, pedophile next door, nearby not a material fact? Best I can figure is it could be wrong information, because guess what? Convicted felons might have a problem with telling the truth. I'm just making a blanket guess. Maybe some of them, maybe they have to tell where they're living once they get out. Maybe they tell, maybe they don't. Maybe they live where they claimed they were going to, but then they left before they should have. And all that's on the record, according to the registry, is that they live at this place, which is next door to you, and you're trying to sell your house, and some buyer finds out that next door there's supposedly a convicted felon, pedophile, and doesn't choose your house because of it. But that person is actually long gone. The registry was wrong for some reason. So what has happened in that moment is you have been harmed in your real estate endeavors because of misinformation about this presence, or actual turns out not to be the presence of the pedophile. I think that's why this thing is not held to the standard of a material fact. Now, in the interest of protecting a kid, I totally get it. I'm like, can't we just default to making sure the kids protect? Well, this is just the rule. This is what the rule is. We have to work with the rule. The rule is it is not a material fact. Same thing, though. If they come and ask you, is there a pedophile next door? If you know, you could say I refuse to answer, but if you certainly can't lie about it. You can't say, no, there's nobody there. But if you do know and you choose to answer it, it's got to be the truth. When you're a buyer agent or any kind of agent, some of this stuff is probably, and talk to your broker in charge, by the way, see what they want you to do and how they want you to handle it. Probably just best to let them do their own research, right? I mean, if you find out that somebody's nearby, that's your own moral and ethical judgment call you're going to need to make. But as far as every house that you ever show, are you going to do a convicted, or are you going to do a sex offender registry search for it? Probably not, right? If it's important to them, some of this stuff like that, as well as school assignments, right? Things like that. We're not obligated to put the school in onto the MLS. Obviously, totally different in terms of seriousness, but just stay out of it, right? That might be what your broker in charge chooses to advise you on with regard to that. But is the presence of a sex offender nearby material fact? No, it is not. Okay, what are material facts? If I were to ask you, and let me just do that. Tell me, give me an example of a material fact. Just a thing, a situation, some sort of a material fact. Yeah, there you go. Flood zone, leaky roof. 9 times out of 10, those are what people are going to say. Things related, or things about the property itself. HVAC is out, good one. The property problems, the problems with the actual property. But it is also a material fact that the zoning is about to change. It's zoned residential now, but maybe they've decided to change it to industrial. That happened to me. The house I live in right now is the house I grew up in. I bought it from my parents in 2001. Once upon a time, it was residential zoned. Now it's a house. It's just an old brick tri-level. It's nothing special. And it's old. It needs paint and needs a new deck, but it's zoned industrial. And I know the buyer is going to tear it all down and build probably an office park someday. I can't bring myself to spend $2,000 on a new deck because I know this whole place is getting torn down. I do have it on the market. Who knows when it'll sell? It's commercial. So it could take forever, right? Or I could win the $1 billion lottery if I can maybe somehow win it without buying a ticket, because I haven't bought a ticket. Somehow that's a problem. I don't understand why. But things related to the property are things like not a leaky roof, but other things that go on. I live in Concord, just to the east of Charlotte. You know what's famous about Concord? The Charlotte Motor Speedway, which is in listening distance from my house, right? During the race in May and the race in October, I hear it. It's not super loud, but I hear it. There's also a drag strip, which is super loud. There's also across the way, not near me, but across from me, across the speedway from me, near the speedway, there's a landfill that serves 7 counties. It is a very high-tech, technological business. They turn that stuff, they bury it, cover it with plastic. All these little yellow Tonka trucks are moving around. You see it off in the distance. It's this grassy knoll with these little teensy machinery things up there. But there's a couple of neighborhoods, minimum $400,000 or $500,000 price point. Some of them $700,000-800,000, right next door. Now, when you drive by, you just see this grassy hill. Then you turn into that neighborhood. But sometimes they'll get the wayward grocery bag flying through the air. The little plastic bag gets caught up and escaped from being buried, and it blows. I saw one the other day in somebody's yard in a $500,000+ neighborhood. And every now and then they might smell something. For the most part, it's okay, but you better believe you need to disclose that it's there if you're the buyer agent. On the other side of town, Highland Creek is a pretty well-known North Charlotte neighborhood. Skybrook is another one, and they are both in smelling distance of what I affectionately call the poop farm. Wallace Farm has got little Shetland ponies, little mini horses, and they do what horses do, and they make amazing dirt. If you want to grow tomatoes, buy that rich, dark soil from that farm. But occasionally you're going to smell, let's just say, sort of an earthy tone, an earthy aroma. When you look up houses for sale in Highland Creek and Skybrook, I had one in Skybrook a couple years ago. I disclosed that Wallace Farm was nearby because I knew you could smell it every now and then, but nobody else that was on the market did. And it doesn't matter until it does. Somebody could complain. Did you disclose? It is a material fact that it relates to the property. It's nearby. Or how about a flight pattern? Because you're near the airport and they go over your house all the time and it's noisy and it knocks the figurines off the shelves or whatever. So related to the property as a material fact, about the property as a material fact, and then the money. The money is a material fact too. When I say the principal's ability to complete the transaction, what's an example of that? In what way could a principal, by the way, is either the buyer or the seller, the people involved in the sale, not the agents, but the people who are either buying or selling. One of them, their ability to actually complete the transaction. What sort of thing am I talking about? What could keep that buyer from buying? There it is, Carrie. You got it. The buyer tried to get a loan and the lender said, nope, not giving you a loan. I've looked at your bank statements, your tax returns. I've done all my research, and you know what? Your credit score, everything. No, we just don't feel confident in giving you this loan. Denied. The minute you find out that your buyer can't get the loan, material fact that you need to tell the other party ASAP. Got to tell that seller's agent so they can tell the seller that the buyer can't afford this house. Or on the seller's side, the seller might get a foreclosure notice in the mail, right? Maybe it come to find out you had this listing for a couple of months. You got a buyer, you got an offer, and the seller didn't tell you, you're their listing agent. They didn't tell you that they had fallen behind on their mortgage payment. They were 3 or 4 months behind and they never told you. And then halfway through the under contract period, maybe even 2 or 3 weeks before closing, the seller gets something in the mail from the city, the county. We're foreclosing on you. The foreclosure notice from the lender, not the county, the city. The lender sends them a foreclosure notice. That's the principal's ability to complete the transaction. Is the seller going to be able to close on this thing in light of them being foreclosed? Now, you might get lucky. The foreclosure process might take longer than getting it closed with this buyer. You would definitely have to call the seller's lender and say, hey, here's the situation. I know you want to foreclose, but the buyer exists. We're supposed to close next week. The seller is going to have enough money left over from the closing to pay the 4 back payments they owe you because they're behind on the payments to you. Are you going to maybe just pause the foreclosure and let us just have a closing so we can pay you the loan balance plus the penalties? And the lender probably would be okay with that as long as they're getting their money. But in 2008, we had lots of sellers that weren't so lucky to have values as high as they are now. They were in a bad situation, but the house wasn't worth enough to sell for enough to pay that lender everything that they were owed. And that's when we had things like short sales. You might have heard about a short sale. We'll talk about that in a finance chapter. The principal's ability to complete the transaction. Can the buyer get the loan? Did the seller get a foreclosure notice? Things like that. Maybe the seller declared bankruptcy. That could affect the transaction's completion, right? Here's a little caveat, a little nuance to write down, because this could show up on the test question. Definitely have to disclose if the seller gets the foreclosure notice. But what if the seller is just 2 or 3 months behind on their payment? Is that a material fact? The answer might surprise you. Is it a material fact that the seller is behind on their house payment 2 or 3 or 4 months? No, it is not. It is not a material fact if they're behind on their house payment. It is a material fact if they get the foreclosure notice. So know that distinction. Basically, if they're just behind on their payment, they could catch that up. There's nothing that affects the buyer. The seller could maybe, or they might even close in time to be able to just pay off the loan without having to get foreclosed upon. As long as the foreclosure process hasn't started, there's nothing that needs to be disclosed to the buyer. Late payments, being behind on the house payment is not a material fact. And then this fourth bullet point, that's a pretty broad one. Anything important to the parties is considered a material fact for that person. What in the world does that mean? So I think it was the third year in the business. I worked in the university area of Charlotte. There was a neighborhood back then in the 90s called Radburn. It's still there. But at the time, it was like the highest end neighborhood for a ways, for a pretty good amount of miles in that part of town. And I managed to somehow get a listing in there. It was about $350,000 listing, which is a pretty upper end listing at the time. The buyer who came along and made an offer, and we took their offer, so we got under contract. This buyer had come from Florida. And down in Florida, they had a little child, a little toddler, running across the backyard. And while that child was running across the yard, a termite flew out of the sky and swooped down and picked the child up. And no, it didn't. That's ridiculous. That could never happen. But in Florida, termites are really bad, okay? So bad that buyer coming up here from Florida had kind of had a lot of financial difficulty. They had, because of termites, had to shell out a bunch of money. And so they were kind of freshly sore. They came up here and they talked to their buyer agent. And they're like, whatever you sell us, it cannot have any sign of any termites ever in the whole world. If a termite burped on it, we don't want it because it's too soon. We had that deal down in Florida. We can't do that. So for that buyer, the presence of termites in any way at all was a material fact. Well, wouldn't you know it, Murphy's Law kicked in. When they had the inspection in the crawl space of my listing that they were going to buy, if you push the insulation over a little bit, on the side of one of the pieces of wood was a little bit of nibbles, that one little termite. It was a very tiny bit of surface damage. So little that if somebody had seen it before we listed it and had some sandpaper in their pocket, they could have just rubbed a little bit of sandpaper on it and nobody would have ever known what that was. That's how little, I'm not saying they should have, but that's how little there was. But it was there. And that's all it took for this buyer. They're like, nope, we're out of here. We told you from day one, not interested in termite properties. It was surface damage, no structural, doesn't matter. Seller's willing to treat it, doesn't matter. I'm out of here. So, anything important to the parties? What other things might be important to the parties? What else might be something that a buyer or seller would insist upon and therefore be a material fact for them? Think maybe permission to use it in a certain way. So, Gregor, they lost their due diligence. It wasn't active. At the time, this was before we did due diligence money. So it was a whole different ball game back then. But if it were today, they would have still lost their due diligence money. And if they backed out before the due diligence period, they would have gotten their earnest money back. But back then, we didn't handle it that way. Yeah, there you go. Some sort of an easement. I had a listing one time with a gorgeous backyard, nice and flat, perfect for a pool. So if you just looked at it out the back door, saw this huge green backyard, you could imagine a pool being there, but what you didn't know was under the ground was a gas line easement. The utility company, the gas company, had a gas line right in the perfect spot for a pool. So we had to make sure that everybody wanted to have a pool there, and we had to tell them, look, sorry, there's a gas line that can't be moved there. So the pool would have to be put in some weird place off to the side. So yeah, you bet. All those are good ones. Anything important to the parties might be important to the party that they can have an 8-foot privacy fence. That's kind of extreme. Most privacy fences are like 6 or less, but I've seen some neighborhoods with an 8, and for some reason that seller wants it, it's important to them, right? Restrictions, good one, Carrie. Covenants and restrictions. You might see the abbreviation CC&R, conditions, covenants, and restrictions. As a buyer agent, you want to get a hold of those rules, those covenants and restrictions to show your buyer, to make sure that nothing in the rules of the neighborhood will be something that will keep them from wanting to buy it. Yes, good one. Fence over the line, that's an encumbrance. We're going to get into that in chapter 2. That would definitely be a material fact if it crosses the line, you bet. They have to be disclosed. If we don't disclose them, we, the broker, is guilty of something. We're guilty of one of these huge words that shows up in the comments section around page 4 or 5, and it's either a misrepresentation or omission. What the heck is the difference? Let's talk about it. This is a big one, guys. I ask you to read the first 4 pages of the comment section. I'm going to ask you before Monday to, what day? Oh, next Wednesday, to read the next 4 or 5 pages, which includes this stuff. This is big. They can ask you lots of test questions about this sort of thing in the comment section for each of the 4 combinations of these words. I'll show you in a minute. They give you a couple of scenarios for each one. So it's either going to be willful misrepresentation or negligent misrepresentation. Let's look at this first, and then we'll come back to here. It's going to look like this when you put the words together. If a broker is guilty of willful misrepresentation, that means they told something that wasn't correct. Did they do it on purpose? If they did, it was willful or intentional. Or did they tell something that wasn't correct because they just didn't know any better? Doesn't mean that they were any less responsible. They still were responsible for doing the right, saying the right thing. But that's the difference between willful and negligent. If they did it intentionally to trick somebody, to defraud somebody, that's willful. If they did it because they were slack and didn't bother to do their research, their homework, and check up on whatever the thing was, that's negligence, right? So they might ask you a whole paragraph of a situation on the test and say, here's this thing that happened. Was the agent guilty of willful misrepresentation, negligent misrepresentation, willful omission, or negligent omission? And when your brain is tired, you're just going to be like, twist it all around backwards, and it's going to be frustrating. What I've found is it's helpful to figure out the second word first. Given the situation, decide if it was a misrepresentation or an omission first, and then decide was it willful or negligent. So what do I mean? A misrepresentation means that they said something. They either wrote it or they said it. They actually addressed the situation. They said, oh, it's fine to have an 8-foot privacy fence. Was that willful misrepresentation? They misrepresented because they said it was fine, and it turns out it was not okay. It was not allowed. But did they do it willfully or did they do it negligently? We don't have enough information. If the test question says they knew that it wasn't okay, but they just figured they would gamble and go ahead and tell them that it was okay and hurry up and get it closed and get their money and run away, that would be willful misrepresentation because they knew better and they said the opposite thing that was true. But more likely in real life is this: negligent misrepresentation. They said something because guess what? Real estate agents can start running their mouths, right? That's sort of a product of just a sales atmosphere. We talk too much sometimes. So if you let your mouth get ahead of your brain and you say, oh, yeah, I'm sure that's fine. I'm sure it's okay to have an 8-foot privacy fence without looking at the covenants and restrictions, and then you never bother to get them and you never bother to look at them, and your client is just going off of your guess that one time that you pulled from air or some other place, then what you're guilty of is negligent misrepresentation. You were slack, you didn't bother to find out, and you mouthed off and said a thing that was wrong. You see the difference with these two kinds of misrepresentation? The omission one means you didn't tell them a thing. Remember your mom or grandma or somebody back in your history said you lied by omission. You should have told me that you were going to that place. You told me you were going to the mall, but you didn't tell me you were going to the place after the mall. You didn't tell me. That was a lie. Don't think about that when it comes to this. It'll throw you off. Omission means you didn't say something. Misrepresentation means you did say something. Omission could be where you didn't bother to tell them that there is thyroid cancer clusters in Mooresville. True story. In Mooresville, near the Duke Energy plant, coal ash, all that fun stuff, there have been a cluster of people, a cluster of cancer cases. Is that a material fact? It's kind of tricky. Yeah, but it's not recognized officially. Yeah, there have been cases, but there's not yet been, as far as I know yet, some sort of a CDC announcement that this is an official thing. Certainly advise your people that this might be the case. If it's on well water, let's make sure that we get that water tested, or maybe they don't even want to bother with that, so let's just not consider that area. If you don't even talk about it, that's omission. Did you not talk about it because you just didn't want them to get scared and you're like, I'm sure it's fine, I won't mention this? You were intentionally leaving it out. That would be willful omission. What if, though, this happens a lot. That's Mooresville. What if you're coming in from any of you guys? You're coming in, you could come here from Wake, from Raleigh, from even closer in, you could come from Ballantyne all the way across Charlotte up to Mooresville and not really know the market. If you're coming from Ballantyne to Mooresville or Ballantyne to Concord and you don't know about the landfill or the poop farm or the airport, or in the Mooresville case, the cancer cluster, you need to know the market that you're working in. Yes, you could certainly go up there and do the work. You can look up the MLS, how much things sold for, figure out what something should sell for. But what you don't know are the little things that you learn when you live in a place. So as a business practice, yes, you could theoretically go there and sell a house. I get South Park agents, South Park down in South Charlotte, who come to Concord all the time. And that's okay. But just make sure that you know what's up in Concord. Make sure that you know that's a landfill 100 feet away. Might be something somebody has to smell sometimes. Make sure that you know Huntersville has eye cancer clusters. Mooresville has thyroid cancer clusters. Are they a situation your buyer should be concerned about? That's for your buyer to decide. Maybe it's easier just to remove the liability from your shoulders. And if you're coming to a place that's somebody wants to buy in Mooresville and you're used to Greensboro, maybe just refer it to somebody in Mooresville who knows about Mooresville. And then you'll forget you did it. And in 6 months, you'll get a referral fee out of the blue, and it's like found money. So referral fees are the unappreciated benefit of having your license. It's a good thing to do, to use referrals. Okay, good question in the chat. If a broker's found guilty of any of these 4 things, would that be a situation where the buyer could get their due diligence money back? So usually the transaction is going to be its own thing. They're not going to get that due diligence money back. It would certainly be a case where they could pursue it after the fact. They could make a civil suit. You can sue anybody about anything. They could complain to the real estate commission and try to sue somebody if they want to go through the attorney fee process and all that good stuff. So not necessarily. For one thing, it would depend on the situation. There's a word called a latent defect, the word latent, latent defect. That's a whole different level than disclosing material facts. First of all, without getting too much ahead of ourselves, a seller does not have to disclose anything about their property. There is a written disclosure about the property that the seller is required to provide. But the options on that disclosure, there's 3 of them. For every item on it, they can either check, yes, I know that there's a problem about that with this property. Or they can check, no, there is no problem about that with this property. But they could also check, I'm not telling if there's a problem about that with this property or not. That choice is called no representation. A seller could check no representation box for every item on the disclosure. It's a 4-page document. It's actually 3 pages of checks and lines, a whole bunch of fine print, like 10-point font, little tiny checks, hard to read it. A seller could say, I'm not telling you about anything here. And a buyer would just have to read that and say, well, that makes me think that there's probably things wrong that you're hiding. Or it could be that the seller is perhaps like an attorney and they're just so seasoned about getting liability off their shoulders that they're like, if I have a choice to get the liability from my shoulders and not disclose anything legally, I'm going to do that. But just because the seller can say that they're not telling by checking no representation on the whole thing does not mean their broker has the same privilege. So if you go there for that listing appointment and that seller says, hey, you know what? I'm hiring you because you've got a great reputation and my friend told me that you were great. By the way, we're going to do the paperwork here in a minute. By the way, though, just to let you know, there's a leaky roof and there's a lot of mold in the crawl space, but just keep that between us. You would have a problem because you would have to explain to them, look, you talked too soon. You didn't let me tell you your rights here, because if you hadn't told me that already, what I would have told you, Mr. Seller Client, is you have the right to check no representation and not disclose any of that. But if I find out about any of that, I do have to disclose it. So when I go in on a listing appointment, I make sure to hurry up and tell them, look, guys, here's how this disclosure thing works. It is your right to check no representation. But if you tell me about a problem with the property, or if I discover it in my natural walkthrough, I have a duty to discover and disclose. I'm not putting on fancy hazmat clothes and crawling through the crawl space. But if I open the door, which is a normal thing to do, and I can see that there's a problem from there, or if I open the kitchen cabinet under the sink and I see a leak, I've discovered something that I have to disclose, right? So even if you check no representation on the disclosure, now I know about it. I have an obligation to disclose it. So you got to explain how that works, right? So, but what if the seller, there's this other term that we'll get to in a little while, and it's called caveat emptor. Anybody ever heard of caveat emptor? The Latin phrase, it means let the buyer beware. Let the buyer beware. In this transaction for buying this property, let the buyer beware of the seller, not the broker. Let the buyer beware that the seller might not tell them everything. They have the legal right to say, I'm not telling. They can check no representation. So let the buyer beware of that. The buyer has the right to have any inspections done they want. They can even have their Uncle Joe from California come out, and he bought a house 40 years ago, but they trust him, and they want to have an inspection, and they want Uncle Joe to crawl around and look at everything. Doesn't matter. They have the right to check it out however they want to. That is their right. What if the seller, though, knows that there's a recurring water problem in the basement and they never fixed it? It kept coming back when it rains heavy, at least twice a year. It comes back really bad. And that seller puts the house on the market, but they mysteriously decide to give the basement a nice fresh coat of paint, and they do the floor treatment on the floor to hide the watermarks from when it inevitably floods in the basement twice a year. What they've done there is a step beyond no representation. What they've done is intentionally tried to cover up a recurring problem. That would be considered what's called a latent defect. this thing is not fixed. It's coming back, and the seller tried to hide it. That's something that could be actionable after closing, right? That's something a buyer could certainly sue a seller over. That's more than just seller saying, oh, it's up to you to find it. Not on me. Let the buyer beware. No, seller has an obligation to, and that applies to things like structural problems too. Some major things like electrical issues that could cause people to die, structural issues that could cause things to fall on people and kill them, things that are like a big deal like that. More than just, oh, I'm not telling, cute little me, no representation. It's more than that, right? I don't know about buyer beware being different in other states. Is that what your question was? I just know the North Carolina stuff. Let's go back to the words themselves. So a misrepresentation, again, is what is the agent saying or writing something. Omission means the agent didn't say anything at all. They didn't even bring it up. Now, did they not bring it up because they didn't know any better? For instance, a Greensboro agent selling in Mooresville, not knowing any better about the cancer clusters. So they were ignorant. They didn't know what they didn't know. They didn't bring it up because they didn't know any better. That would be a different thing than if they knew and they were trying to avoid it. Willful means they knew about it and they said the wrong thing. That's a straight up lie. Willful misrepresentation is a lie. And then negligent means the agent should have known in their course of their responsible duties, the duties that we are responsible for, they should have known or should have found out. There's a handful of fiduciary duties that we brokers have a responsibility for. One of them is a reasonable amount of skill and care. We need to have reasonable skill and care when we work with people. Disclosure and reasonable skill and care are two of the 6 fiduciary duties that we owe to everybody. We need to be able, people need to be able to know that we know what we're doing. That's reasonable skill and care. Should have known or should have found out kind of falls in that category. So, beside what we're going to see, well, let's just look at that. Let's take a look at the comments section. There it is. Yes, good one. Somebody mentioned what those fiduciary duties are when it comes to an agent taking care of their customer. And the acronym for that, by the way, is OLDCAR. You're right. OLDCAR, the letters of OLDCAR spell out the 6 responsibilities we have on behalf of our client. We'll get to that in units 7 and 8. So I think page 5. The first one that they talk about is willful misrepresentation. A licensee has actual knowledge and deliberately misinforms. And it might be surprising to see some examples of this willful misrepresentation. The first one I'm going to mention is this second example. An agent knows that the heat pump, let me make sure that I'm sharing. There we go. All right, here we go. The second one here, an agent knows that the heat pump at a listed house does not function properly, but tells a prospective buyer that all the systems and appliances are in good condition. That seems pretty obvious, right? They knew about it. They said it was okay. They knew it wasn't. Willfully, intentionally lied. But look at this next one. First of all, in these last few years, now since April, the market has started to shift. But before April, over the last 3 or 4 years, it has been a crazy Wild West free-for-all out here. If you could manage to get a listing, you could basically count your money. I never advise counting your money before you get it in your hand, but it was almost guaranteed that thing was going to close, if not with the first buyer, at least with the second one, because you had buyers fighting over everything. There were few listings and a lot of buyers, and the supply and demand was out of whack. Still is a little bit, but it was crazy then. So agents were super competitive with each other to get a listing because they knew that was almost guaranteed money in the bank. If you could get the listing, somebody's going to pay over asking price for it. So it became cutthroat. I mean, agents just elbowing their way past each other. you better believe there are lots of agents who went in on a listing appointment and said to that seller, what do you want to sell it for? That's not the way to do it, guys. We don't ask the seller what they want and say, sure, let's just throw it up for that amount. But plenty of agents did that. The proper thing to do is to say, what would you like for it? That's just nice to know. And then do your own research and see if they're crazy or not. They want $450, but you can't find any justification for this thing to be worth more than $420. Now you're going to have a conversation. Are you seeing the hands? Okay. You're going to have a talk with them about, I can appreciate that you want $450, but want and can get are sometimes different things. And nobody has been willing to buy something like your house for more than $420 in this neighborhood. Yeah, but I have well, they had more than that, right? But there have been plenty of agents who told the seller whatever they wanted to hear, and I call it buying the listing. They basically say they didn't even really show any research or homework about the valuation. They didn't prove what their research showed that the house was worth. They just went in and said, what is it going to take for you to let me put my sign in your yard? Oh, I want to try 500. And you're like, oh my gosh, the comps are showing 420. They want to overprice it by $80,000. But in the most recent market, we just kind of started to get away from, not the worst news in the world, because might be kind of likely that you're going to get a competing offer situation that will bring it on up close to 500. But look at this. Look at this example. An agent knows that the approximate market value of a house is $225,000, but they tell the property owner that it's worth $250,000. Why? In order to get the listing. The Real Estate Commission has put this in this comment section as an example of what you could get in trouble for, called willful misrepresentation. If you know it's not worth what the price is that you list it for, and you do it with the intention of just getting the listing, that's an acknowledged example of willful misrepresentation. And this happens every day, all the time. There's overpriced listings all over the place. Are people getting turned in over it? Maybe. I don't hear about it that much because usually it all works out. If you do it and overprice it and it gets pretty close, doesn't mean the seller's going to be mad. They might be fine. They might say, well, we didn't quite get what we hoped for, but we got it sold and you were great. But if the seller is mad about it and decides to turn you in and start throwing the agent under the bus because, well, gosh, I sat here for 6 months. You should have told me it was only worth $425. Why did you let me list it at $500? Because you wouldn't have given me the listing without me agreeing to your number. That would be a problem. Now you're in trouble. If they decide to click the complaint button at the Real Estate Commission website, now this matters to you. Now you could be facing willful misrepresentation. I just thought that was pretty interesting because it's so prevalent. There, some agents, I could name them. I never will, but I sometimes will see a listing with a certain firm or a certain agent. And I'm like, I just know because it's that agent that it's probably overpriced because they always do it. Now we're in a market where it's kind of not as big of a deal again because things are kind of still very competitive and there's a lot more buyers than there are listings still. But just be aware of these examples of these 4 possibilities. Look at the next one. An agent is unfamiliar with the features or condition of a listed property, but they tell the buyer that the plumbing is in good shape. They don't check first. They just say, I'm sure it's fine. The agent in this case is acting without regard for the truth. The plumbing, in fact, does need significant repair. Therefore, the agent is guilty of willful misrepresentation. They said something. They knew it didn't work. They said it did. They basically lied. So read through this over and over. Maybe even try to read one of these and swap out in your mind the situation. Could be water intrusion here. Could be power issue. Maybe if you, maybe the circuit board, the breaker box isn't enough. The lights tend to keep popping off with the hair dryer, right? Just one little hair dryer or something. Could be anything. You could see any sort of a little narrative story that they're going to make up and say, what did the agent do wrong? What was it? Which of these things was it? The next one we'll talk about after break because it's 8:30. Let's come back in 10.
Hey, what's up, guys? So yeah, I'm just out here trying to keep a super positive spin on the market because there is so much to be positive about with this situation. But that's what I'm doing. I'm just every day trying to see how I can turn the current data and the current market shift into this amazing Hey, what's up, guys? So yeah, I'm just out here trying to keep a super positive spin on the market because there is so much to be positive about with this situation. But that's what I'm doing. I'm just every day trying to see how I can turn the current data and the current market shift into this amazingly positive thing for you guys. So that's what I've been about since day one, is to prepare you for the market crash and let you know closings happen every day. Why do you think I have all those affirmations there, right? The second post, look at it. Look at the affirmations. It's what I've had up there for years. So anyway, on the next slide, I've got tickets for you. I'm going to be in Biloxi. I'm going to be in Vegas. I'm going to be in New York. I've got other events that I'm putting together now for, February and mid-year next year, stuff like that. So looking forward to seeing all you guys and continuing to spread this message of positivity about the market and the fact that we can make it no matter what is going on with the market.
All right, it's time. Oh, my shoe came off. It's time for a puppy break. I'm coming in hot. Coming in hot. Coming in. You guys are all wet. I'm in costume. I can't even handle it. You guys are so cute. Oh.
All right, we are in Vegas.
This is crazy.
Sorry, bear with me. I'm trying to find the source of that noise. I know why it started. I just don't know where it is that's making it keep out. Can you hear something? Hear music? You do hear music? Okay. Okay. Where did it go? That is annoying. There we go. Okay. All right. Back at it. Let me see. Let me catch up here in the chat. Oh yeah. Okay. Somebody asked about how to, like the little helpful hint I gave you about how to figure out what we're talking about. The first thing I would do is to figure out, is it misrepresentation or is it omission? Figure that part out first. In other words, did you say something that wasn't true, or did you not say something but you should have? Then figure out, did the agent say something that wasn't true to defraud intentionally? That would be willful. Or did they say something that wasn't true because they didn't know any better and they were too lazy to check it out and figure it out? Or did they leave out the information, omission, intentionally, hoping the person wouldn't know any better? Or did they leave it out because they didn't know any better themselves? Negligent versus willful. So I don't know. Tell me, do you need one of these slides? Somebody need to see one of these slides for a screen cap or something? Okay. All right. What are some other things that we could, by the way, read 5 through 9 or 10, get through the willful, negligent, misrepresentation, and omission part of the comment section? Some other things that agents do that they can get in trouble for are these. Also, right after the willful and negligent omission and misrepresentation section in the comments, they deal with these situations. False promises. I mean, the classic thing that salespeople are assumed that they're going to do. They're going to just lie, or they're going to make promises they don't ever keep. Sure, I'll do the spray treatment underneath the car salesman. Yeah, sure, the warranty is good for 10 years when it's really only 8. Whatever it may be, extends to any sales position. So the commission says if a licensee makes promises that they don't fulfill, we can discipline them over it. That is against the rules, against the laws. Improper commissions would be paying an unlicensed person for real estate activity. That's against the rules. Incompetence, unworthiness, that falls back to this idea of reasonable skill and care. If you don't know what forms to use and the client gets hurt because of that, because you used the wrong form and didn't have enough protection in it built in, because it was, for instance, when you sell a property with a structure on it, you're going to use a certain kind of contract that is designed for properties that have improvements or buildings on them. But if you're just selling raw land, you're going to use an entirely different kind of contract because it doesn't have any buildings. So therefore you don't need things like a warranty. There's no warranty for dirt. There's warranty for houses. And so the house contract that we use, the standard form that we are given to use, is called 2T. You won't need to know that, but it's called Offer to Purchase and Contract Form 2T. The one just for land with no house, no structure, no building on it is 12T. You need to know, oh, I'm selling land, so I don't use 2T because that's for if it had a house on it, I need the one for land only. So how in the world are you going to figure this out? Training. Your broker in charge. That's why you have a broker in charge. Oh, hey, broker in charge. I just got this person that wants me to list their acreage. They want me to list 4 acres of just raw land. That broker in charge is going to say, well, here's how you do that. By the way, land, not easy, not necessarily difficult just because it doesn't have a property on, doesn't have a house on it. Land can be the most complicated transaction you'll ever deal with. It's got a lot of issues surrounding it. It needs to be zoned properly for what the client needs. It might be zoned for what it needs, but maybe some little nuance it can't be extended on, or you can only have so much surface area or impervious area, meaning concrete covered where water can't seep down into the earth. All kinds of stuff. Environmental concerns. EPA, right? What was on there before? Was it a business like a car detailing or a car painting business and they just dumped the paint in the soil out back? And so now all that soil has toxic chemicals in it. And when it comes to that sort of EPA stuff, they follow the path of least resistance. The authorities come after the person who has money. Doesn't matter if the current owner is not the one who did the pollution. If they're the only ones that can be located, they're the ones that have to pay for cleaning it up. The guy he bought it from was the one who put all that old paint out there. But that guy's either dead or broke or bankrupt, doesn't have the money, so it's going to be the current owner that has to pay for that cleanup. And that's expensive. Taking out dirt with oil in it, with paint in it, putting in new. So land can be the most complicated. So it's tricky. You need to know what you're doing. So you need to have a good BIC. You need to have good training. Discrimination is a big one. We talked about that top of our time together tonight. Chapter 19, we'll get more into fair housing laws. Basically, we do real estate for everybody, regardless of what they believe in, what they look like, where they came from. And that's exactly how I explain it. I say, look, people, look, seller, I can't advise you to not sell to somebody because you don't like what they look like or what they believe in. You're Baptist and they're Muslim and you're not selling because of that. If I can't be a part of any of that, I can't give you any guidance there. That's illegal. That's a protected class. Religion is a protected class. In chapter 19, we'll cover all 7 of the federally protected classes under the fair housing laws. It's familial status. Is there a kid, underage kid? That's what familial status is. You can't discriminate. You can't not rent to somebody because they have a kid. Yeah, but the kid might damage the property. Doesn't matter. That's illegal. You can't say single occupant only because if they have a kid, underage kid, you'd be breaking the familial status category of fair housing. Familial status, race, religion, sex, handicap, color, national origin. I think I got them all. There's 7 of them. And then also, if you're a realtor, the Realtor Association added 2 more. Sexual orientation, gender identity. Basically, real estate needs to be easily accessible by everybody, regardless of those categories. I'll take a commission check. I'm going to help anybody fairly. I want to help whoever wants to do real estate activity. And it gets real tricky if your client, maybe they didn't reveal themselves to be the horrible racist bigot that they really are until you're halfway through the transaction. And now you have a decision to make. You have to be like, oh my gosh, because they could take you down with the ship. You find out that they're making decisions based on these things. So how do you avoid it? You explain where you stand on those issues in the beginning so as to not work with them from the start. So you don't have 40 hours invested and then find out that they're breaking federal fair housing rules. And now you have to dismiss yourself from it and you've got a bunch of time put in. Let's figure that out. Let's let them know where you stand. Hey guys, this is how this works. These are illegal activities. I don't operate that way. I think real estate's fair should be available for everybody. So I will not be a party to keeping somebody from buying or selling something because of these categories, right? So we'll get more into that later. That is prohibited conduct as well. You will get so tired of hearing this next one. We say it a million times, especially in chapter 7 and 8 when we're talking about, and 9 and 10 too, contracts. we are not attorneys. We can't practice law. Sometimes the client says, can you write in there some extra information in that offer? I want to make sure that that seller does this and that and the other. All we are allowed to do as a broker is fill in the blanks with what goes in those blanks. We can't say, see addendum Z. And addendum Z is this huge piece of paper where you just put on your Ally McBeal, Matlock, name your favorite attorney impression, and you just write all this legal language without a law license. We can't practice law. That'd be practicing law without a license. That's called drafting language. Drafting legal language is illegal if you're not an attorney. We can't practice law. We can fill in blanks. We are allowed to fill in blanks, and that is it. The commission put this one in. I love this one. It's number 15. You don't need to know it's number 15, but I remember it because I always laugh about it. It's a violation. It's a prohibited act to violate any rule. It's like, let's just snowball. Let's just pile on, right? They did something wrong, but it's also wrong that they did something wrong. So it's sort of that goes back to that competence thing. Got to know the rules. And you can't lie about things. And this last one, injunctive relief, that sounds, I'm rewatching, never watched it before. I'm just now learning about the series Suits. Anybody ever watch Suits? It's about attorneys in Manhattan. So I got all these legal words running around in my head for this silly little show. Injunctive relief is what the Real Estate Commission does to people that try to do real estate without a license. I one time had a listing and somebody called me on the listing. And that's great. You're like, that's what you're here for. You're like, oh, great. Maybe you're the buyer. They called me and they were asking questions and they're like, well, is it this? Is it that? And I'm answering questions. Eventually, I realized that this was not a buyer. And I said, wait, so you're not the actual buyer? And then I'm thinking maybe he's calling for his friend or his parent who is the buyer. Sometimes that happens. No, it's not that. Okay, what are you? Are you an agent? No, I'm not an agent. He said, I've got an investor friend and I try to find opportunities for them. And I'm just calling on your listing to see if it's something my investor friend might want. And then the alarm bells went off in my head. Why? So this guy was not calling for his own purposes as a buyer. It's for his friend's purposes as a buyer, asking me real estate questions, basically doing real estate without a license. He said he wasn't an agent. Did we have a problem? Maybe. If his friend, the investor, was paying him sort of to be a bird dog to find these opportunities, then that's illegal. And I eventually realized from the other things he said, you know what? If you're doing these things for your friend for money, then you're practicing real estate without a license, and that's illegal, and the Real Estate Commission could come after you. That is injunctive relief. The commission going after somebody like that, who is doing real estate for someone else for money without a license. That's what it's called when they do that. They're there in that regard. You could kind of say, well, they're kind of protecting us in that way. They're kind of helping make sure our career, our industry is sort of held to a certain standard, and we don't have to worry about competition by people who took a shortcut and didn't bother to get the license. But it's really all about the consumer because, yes, it is more of a risk that a poor consumer who doesn't know any better is being helped by somebody that doesn't have the qualifications, that doesn't know the laws and the rules as they should because they didn't get the license, yet they're helping them with real estate. Now, with that said, could you help your sister find a house and go line up appointments for her and go look at houses with her and then walk through the house with her and say, here's where you could put the sofa. And oh, by the way, did you talk to that lender that I found for you, that online lender with Rocket Mortgage or whatever? Could you do that for your sister? You're basically being a buyer's agent for your sister. I don't have it close at hand in front of me. Maybe I do. But it's my favorite answer in real estate. And where did it go? in that situation, we don't have enough information. The word I'm looking for is it depends. What you don't know is whether your sister's paying you for it or not. If your sister's not paying you, but you're helping her do the real estate, then it goes back to yesterday. You don't need a license. It's up to your sister as to how much she trusts you to be able to do it properly, right? But you didn't break any rules. The commission's not coming after you for injunctive relief because you didn't do it for money. But the minute you do it for money, then we have a problem. It's this thing. Think this. So many things, so many answers in this business depend on other issues. So many questions and answers on the exam depend on things. Do you have the information you need? Right? When you're reading that test question, skip to the last sentence and see what they're getting to. What are they asking you in this question? Then go back and read the whole question. What they will also do, that the commission, is put more stuff in the question than you need. So you got to know enough to figure out which things to throw out sometimes. But just a blanket statement of what is this thing? Is it this or is it that? You need to know what you need to know in order to answer the question, right? What else? If you do something really bad, oops, let me change this, and you just really screwed up, the commission might say, you know what, we could discipline you, but it might be best if you just get out of the business altogether. In that, we saw one of those yesterday under the disciplinary stuff. It said the person surrendered their license voluntarily. And the disappointing part of those is that we never get to find out what went wrong, what they did wrong. But surrendering the license, you don't have to admit that what you did, but you're just saying, I'm out. I won't do this anymore. I'll surrender my license. And then I've already mentioned that when many times you see that they were suspended, that the commission will say, we're going to suspend the suspension. You get to still do real estate, but if you don't do it according to these conditions, or if you don't take the courses we're requiring, then you're going to have to stop doing it. The suspension will kick in. That's what this means, imposing restrictions. Remember the trust account? If your firm has a trust account to hold the earnest money, they've got to follow very specific rules about those other people's money. And if they don't do it right and they end up having their own money in the same account as other people's money, it's this word. This is a big one. Commingling is what it's called when a real estate firm or an attorney uses their own account to put other people's money in. Commingling is when you're mixing your own money with the consumer's money or with someone else's. They need to be put in its own trust account. And here's how this commingling thing could happen without you even really knowing. It's allowable for you to open up a trust account for your firm and for that trust account to be interest bearing. Anybody have a savings account? Do you make money on your savings account? What kind of return do you get on your savings account? Not much, right? Low risk, low reward, right? You're not worried about what's in your savings account. It's not like going down with the stock market, but it's also not paying you that much either. Well, your checking account, when you set up this trust account, it could be drawing interest. And you might like that. You're allowed, as the one who has the trust account, to make and keep that interest that has been earned. So if you have like $10,000, $20,000, $50,000 worth of earnest money, trust money in your trust account, that might draw some decent interest for you that you get to keep. You have to disclose to the people whose money that you're putting in your trust account that it is an interest-bearing account, but it is allowable for you to get that interest if you're the one who owns that firm and has that trust account. But what do we know about checking accounts? Do they give them away for free? You got to pay fees for checking accounts, don't you? And that's what a trust account is. It's just a checking account with the word trust account written on it. So everybody knows this is not my money. This is other people's money. It's where I'm parking it. Well, you've got an interest-bearing checking account that is a trust account where you put other people's money, other people's earnest money deposits because it's your firm. So you've set this thing up as a convenience. Well, you got to pay the fees. How do you pay the fees for that account? How does the bank handle fees? They just pull money from your account to pay the fees for that account, don't they? So you're allowed to have as much as $100 of your own money in a trust account to cover the fees as they are charged every month. Okay, so let's say you put a full $100 that you're allowed to have in there of your own money so that you don't have to worry about it every month. You don't have to worry, do I have enough in there to pay for the charges of the account? But you also have an interest-bearing account. You already have the most amount of your own money in there, the 100, but you have enough of other people's money that the interest bumps it past that $100 mark. You've just commingled because the interest added to your $100 allowance maximum, right? So you got to be careful when you have a trust account. That's why so many firms don't bother with it anymore. You're not making $1 bazillion on the interest of other people's money, of these earnest money. You'd have to have a pretty big one. It'd have to be a big firm with a whole bunch of trust money, whole lot of deals going through. Probably not worth the trouble. Certainly not for me. I don't want to hassle with worrying about accidentally commingling because I earned so much interest that bumped me over my $100 amount that I had in there to cover fees. I don't even want to hassle with it. And a lot of other people don't either. So commingling just means that your money is mixed with other people's in the account, and that is not allowed for trust accounts. You need to have a separate operating account for your firm and then a different account that's a trust account for the earnest monies. Okay, let's see. We talked a bit about advertising already. In order to advertise a property, you got to have permission to do so, right? You can't just do it without that seller knowing. The seller has to give you explicit permission. It's built into the standard forms that we use. The listing agreement that we use when we list a house for sale, when they hire us to sell their house, that listing agreement has in it that the seller gives you permission to advertise it. And sometimes they might give you permission to run a print ad, but not an internet ad. It breaks it down. What are you allowing me to do? Will you allow me to do an open house, a print advertising campaign, internet advertising? I would hope so. You also need permission from your firm, your broker in charge, right? They need to verify, make sure that you're running the ad properly. Got to run it by them. Sometimes BICs require you to run all ads by them. Sometimes they just say, here's how we want you to do it. Here are the guidelines. Don't screw it up. So some will give you more wiggle room, more leeway than others. Let's see. And then we talked about blind ads. When you have any documents in a transaction, there's a lot of them, by the way. Let's say that you're a buyer's agent. You're helping a buyer buy a house, and they find one they like. You've shown them 5 houses. They pick one, and you make an offer. You put an offer together, and you submit that offer. You need to keep the offer paperwork for your own files, but you also need to deliver it to your client and also turn it into your firm. And you got to give it to your client immediately, but not later than 3 days. Several things in this course are that answer: immediately, but not later than 3 days. So if the answer choices are, Sarah, buyer agent, wrote an offer for her client. It got turned down. She wrote 3 more offers on 3 more properties. She provided all of the paperwork from all of the offers to her client. When is the latest she needs to provide it and give it to her client? All these offers that she wrote on their behalf. If the answer choices are immediately, 3 days, 5 days, 7 days, the best answer choice out of that group is immediately. But they might throw you a little curveball. They might say 3 days, 5 days, 7 days, or 10 days. Immediately is not an option. So the best answer out of that group would be 3 days. But in real life, in the real world, deliver documents to your client It could be offers that you've made for them. It could be if you're a listing agent and you receive offers. We talked about how crazy the market's been, and we talked about how much over asking price people were getting and how much non-refundable due diligence money. We didn't talk about this. How many offers are people getting on their properties? Any guesses as to how many offers some of these sellers are getting? What are sellers getting for their properties? Number of offers. You heard of any examples from friends, family? Yeah, not unheard of. 10, 15, 20, probably 50 sometimes. A lot. Obviously, you've got to present all offers. That's testable item 2, by the way. Listing agent has to present all offers to their seller, period, no matter what. What if the seller already has 50 offers and they've already said, look, I'm only going to consider the offers that come in by noon today. You tell everybody in the whole world, bring us your offer by noon today. The seller will pick from whatever comes in. But at 1:30, an hour and a half later, another offer comes in. Do you need to give it to your seller? They just told you they were going to pick from the ones that came in by noon. So what's the point? It's an offer. You got to submit it. You got to send it into that seller as well. So be careful about that. Doesn't matter what the seller wants. We do have to follow their instructions, but they got to be lawful instructions. It would not be lawful to hold back an offer. So we got to deliver offers, contracts, amendments, addenda, anything that they have to sign that's related to that transaction, documents to our client when? Immediately, but not later than 3 days. The 3 days is sort of an old-fashioned number. It's there because of what? Snail mail. Back when we actually mailed things. We don't anymore. It's all email, DocuSign, electronic stuff. We're allowed to do that. It's all valid. You can sell a house without printing off a single piece of paper. We're saving trees left and right. I'm just kidding. But kinda. It's more and more transactions are with less and less paper. So it's left over from when we actually had to mail things back and forth. It allowed 3 days for it to ride in the mail truck. But it's still the rule. Immediately, but not later than 3 days. And then we have to keep the records. All of that paperwork we have to keep in our files for how long? The number 3 again, but this time 3 years. We need to keep it for ourselves and turn it into to our firm. Good news is you can keep it electronically. You could turn it all into a thumb drive and then shred all the paper. If you just want to have a bunch of electronic files, that is allowed. You might want to have some redundancy built in. You don't want those thumb drives to fall into a bowl of magnets and then go away. And then next year, the real estate commission comes down and says, hey, we need to see that paperwork. I'm sorry, my thumb drive blew up. Not going to be good enough. You got to keep your stuff for 3 years. Whatever. Lots of documents. And by the way, retention of records. We're not just talking about paper. What else is involved in a transaction? How do we communicate with people? You got to keep emails and texts, guys. That's kind of a pain in the butt. You got to keep your text chains for 3 years, along with your emails, along with all the communication. Oh, faxes too. Don't forget the faxes. I'm just kidding. But yeah, if you were faxing, nobody's faxing. But if you did, retention of records, 3 years. Should you keep it longer than 3 years? If you end up on the wrong side of a lawsuit, it might be helpful that you have some proof in your favor. So it might not be a bad idea to keep it for longer than 3 years. But the real estate commission's requirement is at least 3 years. That's what you'll be tested on. What you charge, let's see, brokerage fees. You got to have permission of the owner and the broker in charge. The way the brokerage fees work, certainly what we're talking about, how does the money flow in a transaction? The seller typically agrees to pay the agent that they hire. The seller's going to pay their listing agent. And that listing agent is going to share that money with the buyer's agent. What if there is no buyer agent? Then the listing agent keeps all of the money, maybe. unless the seller has a bright idea and says, why are you keeping all the money? There's no other agent. Can't I get a discount? You willing to give me a discount? Maybe they will, maybe they won't. They don't have to, but they might want to keep the seller happy. Maybe, maybe not. Business decision. So whatever you decide to share, what amount with the other party, if you're the listing agent and the seller has agreed to pay you 6% commission on the sale of the house based on the purchase price, what are you going to give to the other party? How much money are you giving to them? Let's look at it. There we go. Okay. All righty. We've got about 20 minutes left. Let's talk about this, but first, let's wake up a little bit. Let's everybody stand up from your seat, just like me. I'm kind of standing up. Do a little shaking it out. Just kind of shake it out a little bit, right? Just kind of get that blood pumping. Let's wake up a little bit. I know it's hard. This is the worst part. This last hour, last half hour, 9 o'clock at night, and you've been up all day. I totally get it. So I just want to kind of help you get that blood pumping.
And we'll talk about some more brokerage activity. I'm going to show you.
Do some math. Are you ready to do some math? We'll talk about how this commission gets split between the two parties.
The buyer agent
and the listing agent.
Then the big bad mean seller. Okay. Oops. I guess I should take that off. That might get annoying.
There, that's
better. That's much better. Are we happy now?
Okay, I won't do that to you. Okay, look. So we've got this seller, and they've agreed to they've agreed to list it with this agent, and they're gonna pay that agent 6% commission. We'll do more of this later. I'm just kind of showing you the dynamics here. And let's say we end up selling the property for $300,000. That's the sale price. There it is. Okay, what's 6% of $300,000? You don't need to know it. You can use a calculator. But you might, because that's not too difficult. It's $18,000. That is the total commission in dollars. Are you getting that as a listing agent? You're over here. You and your firm is over on one side. The firm helping the buyer, by the way, little ahead of the game here, but let me tell you some insight. From here forward, when you hear the word selling agent, the selling agent is always the one helping the buyer. I can't come up with any logical way for you to remember that. I could see the case could be made for either side, but you're just going to have to pound it in. Selling selling agent is always on the buyer's side. So we got a buyer side and a seller side. The listing agent's helping the seller. The buyer is being helped by the selling agent. Let me just replace that with selling firm so that I match the other side. Here we go. Firm. Okay, so the total commission is $18,000. That's 6% of $300,000. This listing firm, the agent who's working for the listing firm, talked to the seller. Right, the seller and the agent had a discussion back when the property was listed, and the seller said, "What do you charge?" And the agent said, "I charge 6%." And the seller said, "You're going to make 6% on my house?" And the agent says, "No, probably not, because another agent will likely bring the buyer." What I'm going to do, and this is totally up to you and your firm and your policy, the firm policy, what you choose to do and what the seller allows you to do. Maybe you decide to split it evenly. Maybe out of that 6%, you're going to give half of it to the other party, to the buyer's side, the selling side. And in this case, that means that you and your firm gets to split between you two $9,000 and the other side gets $9,000. Is this listing agent going to get $9,000 in their pocket from this sale? No. Because they need to split this $9,000. See if I can make it over here. That $9,000 is just what they're getting on their side. It's got to be split and shared with the firm. The firm is going to want some money. Firm and agent. How is that split? Don't know. Different firms have different commission splits with their agents. It might be that you have to be a brand new agent. You might have to do like a lower split and then earn your way up from there. Or it could be another firm just gives you a straight off the top 80-20 split, which would mean, let me show you that one here. Like an 80-20 split would mean that you're keeping 80%. So if it's $9,000 that's coming into the firm, the agent's going to get 80% of that, and the firm is going to get 20% of that. If you're on a team and you're a relatively new agent, maybe it's going to be like a 50-50 split %, meaning you're getting $4,500 and so's your firm. So we'll talk more about commission math at another time. But for our purposes here, what I was getting around to is whatever this is has to be agreed upon, given permission by the seller. Oh, you okay with 6%? If they're not, if they're not okay with that, you may not get hired. So maybe they demand less than 6, and that's up to you. It's a business decision you need to make. Are you willing to work for less than whatever it is that they're not willing to do? Are you willing to come down to what they want? So that's what it means. Both your BIC might say, look, you might be talking to this seller, and let me start a new one. And they say, you know what, we went to high school together, we go way back. And you say, well, I normally charge 6% because that's just what I charge. It's okay for you to say that, by the way. You can charge whatever you want as long as your firm allows you to. But you know what, for you, because you're special, I'll do it for 5. You better have your BIC's approval. Your BIC could say, you know what, we don't discount here in this firm. You can discount your side if you want to, but we're going to expect to get our full 3%. If you want to get less in your split with us, then that's on you. That's what this means. You got to have your BIC's permission, and you have to have the seller's permission about the brokerage fees. We talked about drafting legal documents. Can fill in the blanks. You can't write language. Not allowed to write language. And then disclosure of offers. Got to present all offers, no matter when they came in, no matter how much they are. Sometimes you'll get a client that just is completely flying off the handle. They're super stressed. Maybe they're just that personality type that's just going to react very volatilely. And you're like, oh, I hate giving them bad news because they rip my head off. They're not offended to me. They're not meaning it to me, but I have to absorb it. Sometimes you get people like that, and you're like, they already have agreed to this one. We're waiting for it to be signed. I don't even want to bring them this latest offer because it's a low ball, and they'll just get mad all over again. Doesn't matter. Got to put your big boy whatever's on. Therefore, present all offers, even ridiculous ones. Could be that even if they've, let me ask you this. Do you have to present an offer if you're already under contract? You've agreed upon a price, a contract, you're under contract. Do you still have to present the offers that come in while you're under contract? You kind of getting the hang of this, right? Yes, you do. You have to present all offers. Why? You're already under contract. Why do they even need a new one, another offer to come in? You can't accept it, because they might want to accept it as a backup offer. And if that second offer, that next offer that came in, if that buyer is willing to be in a backup offer position, your seller might like to have a backup plan in place, right? So even all offers must be presented. Okay. Oh, this is a big one. These last two lines, this gets people all the time. Even people in CE classes, even people in post licensing, they get this wrong. And we experienced a lot of it these last couple of years, a lot of multiple offers. So you have a seller that got 10 multiple offers, right? They've got a bunch of offers on the table. Let's say you're the listing agent and somebody called you with an offer and they said, look, remember we had that pre-licensing class back in the day with that weird instructor and it was just kind of lame. Well, I'd love to work with you. I hope we can make this work. How many offers are currently on your listing? Can you tell them the answer? You're the listing agent. They've asked you if there are multiple offers. Can you answer that question? Whose permission would you need to answer that question? There it is. The seller would have to give you permission to answer that question. Yeah. Why might you not want to tell them that there's multiple offers? Because, on the surface, you might think, well, it would always be good to tell them that there's multiples. It's going to make them want it all the more desperately. But that's not the case, is it? There have been plenty of buyers who lost multiple offers one after the other. They tried. I've asked this question in CE classes too. How many did they lose before they finally got one? How many tries? How many offers did a buyer make before they lost it? They lost the next one. They lost the next one. And they finally got a seller to agree to theirs and pick them over everybody else. And I've heard numbers like 5, 10, 15, 20. Can you imagine being a buyer and maybe you're trying to move here because of a job? You've got a family to support and worry about, and it's all shaky. And you've tried to buy a house 20 times over and nobody will pick yours. Maybe the first 2 tries were kind of your fault because you didn't really grasp the fact that the values are where they are and you didn't come in strong enough. But then you started getting stronger offers, making stronger offers, and you still lost for various reasons. That would just drain you. That's going to bring out the emotion. People are going to start really getting desperate. That's when people start putting down $400,000 non-refundable deposits, maybe. But in that situation, you find it's your 5th one that you've lost, and you say, hey, I just got this new listing. I saw that you emailed me. You know what? I don't have it in me to try it and have to compete. Could you call them and see if there's multiple offers? If there are multiples, I don't even want to make an offer. Now, let's set aside the point that if you're not willing to compete and have multiples, you may not ever buy anything right now. Let's just put that to the side. But that could be what's going on. They could be burned out. That's why you need to ask your seller how they want to handle it. And it might not be automatically the smart play to tell everybody, yes, there's multiple offers. You better come in hot, because you might scare somebody away who would have been the best offer. They're just tired. They're worn out because they lost them so many in a row, but they might have actually made the one that worked. So you need the seller's permission to disclose that there are multiple offers. But here's the next question. What if an agent calls you, you're the listing agent, and they say, hey, remember we were in that class together, that weird guy, and I'd love to work with you. I know you probably have multiple offers, but what's the best one on the table right now? Let me go ahead and tell my client so we can beat it. What do we need to beat? Can you answer that question? Can you tell them what the highest offer on the table is? Now, this is sort of a tricky one because officially, yes, you could tell them this. The better question I should ask you is, whose permission would you need to get to tell them the answer to that? Whose permission would you need to tell them what the highest offer is on the table? And it's not the seller's. Not the seller's permission. It's the one who owns the highest offer. It's the one who made it. the one who is the highest offer on the table is the one that you'd have to get the permission of to tell the whole world what the highest offer is. Are you ever going to get that permission? I hope not. That would make me lose all faith in humanity. They'd be really stupid to do that, right? But just know that that is a testable item. So again, if there's multiple offers and somebody asks you, are there multiple offers on your listing? Whose permission do you need to tell them the answer? You need your seller's permission for that one. But if they ask you, okay, there's multiple offers, what's the highest one that I need to beat? It's not your seller's permission that you need. It's the permission of the one who made the highest offer that's currently on the table. Write that down, get that in your brain. They will test you on that sort of thing. Yep. That's an easy one to get wrong because everybody thinks it's always the seller's permission for both of those situations. How we doing? I'm looking at faces. You hanging in there? Okay, so we are almost done. Let's see what we got here. We talked about this stuff. Broker in charge is over everybody. Every firm, every office needs to have one. And let me just finish out. There's two more slides, and then we'll be done with this. And then we can just jump right into chapter 1 on Wednesday. If you're a sole proprietor, that means you're not an entity. When you get your license for the first time, you're a provisional broker with an inactive license. You become active. You join a firm. Now you're an actively licensed provisional broker. You are also what's called a sole proprietor. That just means you're not an entity. You've not set up an entity. You're your own person. You're a human doing real estate. You could be a sole proprietor forever and ever and never set up your own entity. Now, I'm no CPA and I'm not going to give you tax advice, but the last time I checked, when you're a sole proprietor, one of the tax ramifications, consequences as a sole proprietor is you got to pay 15% self-employment tax on what you make. That's one reason. One of the tax benefits of becoming an entity is you don't have to pay that anymore because you're no longer a sole proprietor. Maybe. Check with your CPA. It may not even still be a thing. I'm just giving you an example. There's different rules for different categories, but what you start out being from the beginning is a sole proprietor. Now, when do you need a broker in charge? If you're a sole proprietor, meaning you don't have an entity set up, you need a broker in charge over you, even if you're non-provisional, if you're doing any of these three things. If you're going to hold trust account money for your client, if you are going to do any sort of advertising or promotion, even make a business card. If you have business cards, that counts toward advertising or promotion. And then if you have licensees that are reporting to you, any of these three things are true, and you're a sole proprietor, you've got to have a BIC, right? If you set up your own firm, you have to have a BIC because you set up your own firm, but we're not talking about your own firm. You're just a sole proprietor. That's what you are from the beginning. And if you never change that, you need a BIC over you if you're doing any of these three things. That's a testable thing. So maybe just take a screenshot of this slide because you might see this one. And then finally, we'll call it after this, the broker in charge has to have an active license. They can't be a provisional. They have to have 2 years full-time or 4 years part-time. They have to complete the course. And we know the time frames about that. And then the only other thing after they complete that course is to take the BIC up version instead of the general update. BIC up instead of gen up of the continuing education. Okay. That closes out the amount of license law and commission rules we're going to do for a minute. The next thing we're going to cover for next Wednesday is chapters 1 and 2, or I should say syllabus sections 1 and 2. So work on those, and then after that, you can see the study guide. Just go by that and just keep ahead of the game. Where did it go? Here we go. There it is. So yeah, chapter 1, that'll go by fast. That's like nothing. It's just basically some vocabulary words. 2 is huge. We're going to have a lot to talk about with 2. So you're going to have some questions from 2. It's got some weird words in it. 2 and textbook chapters 1, 2, and 3. So just start working your way on through. And I will post this session to the YouTube channel. If you have questions in the meantime, use the Notion. Please go to Notion and write me a little, just a thumbs up or a note, just to make sure I know that you have access to it. Okay. Other than that, have a great weekend, and I'll see you next week. Oh, whoop! I almost forgot. Put your name in the chat. Gosh, I keep forgetting that. Put your name in the chat before you leave, please.
See you next week.
Okay.
Thank you.
Thank you.
Have a good weekend.
You too.